Okay, let's unpack this. Today, we're plunging into the very heart of India's new criminal justice framework, the Bhartiya Nagrik Suraksha Sanhita 2023, or BNSS.
Hmm.
Imagine trying to navigate a complex legal journey without a clear map. The BNSS is that map, defining every step of a criminal trial, from the first whisper of an accusation right through to the final gavel.
That's a good way to put it.
We're here to explore how these foundational rules are designed to ensure fairness, clarity, and, well, efficiency for everyone involved.
Indeed. And what we'll uncover in this deep dive is how the BNSS meticulously defines that procedural architecture. It's not just about what happens,
Right.
but why it happens the way it does, laying down the precise rules for what constitutes a charge, for example, and how different types of cases, from the really serious ones down to the most minor, how they're handled.
Okay.
Will reveal the intricate safeguards built in to protect the accused, ensure due process, and ultimately a total justice for you, the citizen. It's about understanding how every little detail connects to the bigger picture of a fair legal system.
Our mission today, then, is to give you a crystal clear, comprehensive understanding of the BNSS's core procedural chapters. We'll explore everything from the foundational concept of the charge
For sure.
to how different types of cases are tried, whether that's before a court of session or by magistrates, right down to those rapid-fire summary trials. We'll extract the most important nuggets of knowledge from these, let's be honest, pretty dense legal texts and try to bring them to life with some surprising facts and real-world scenarios. Get ready for some aha moments as we decode this new framework. Right? Our journey into India's new criminal justice system begins where every single case starts. The charge.
The absolute bedrock.
Exactly. Think of it as the ultimate legal first impression, the precise accusation that sets the entire machinery of justice in motion. Get it wrong, and the foundation crumbles.
That's very true.
Get it right, and justice has a clearer path.
That's a critical point. And the law ensures clarity through several mechanisms. One of the most fundamental principles at play here is ad alteram partem.
Latin phrase.
Yes, meaning hear the other side. It's enshrined in the very first provisions on charging. This principle guarantees that as the accused, you have precise and unequivocal knowledge of the accusation against you.
Because without that clarity.
Exactly. How could you possibly prepare an effective defense? It's not just some technicality. It's a core human right, really. It prevents anyone from being left guessing about the allegations they face.
So what are those core requirements? What must a charge contain?
Okay, let's dive into that. Firstly, it demands an explicit statement of the offense. No ambiguity allowed. Crystal clear.
Right.
If the law gives a specific name for the offense, like murder or theft under the Bhartiya Nagrik Sanhita, the BNS, well, that name must be used.
Yeah.
However, if there isn't a specific name, the charge can't be vague. It must define the offense sufficiently to give adequate notice of the alleged wrongdoing. This directly prevents the prosecution from bringing, fuzzy accusations that could cripple your defense.
So it's all about eliminating any shadow of doubt about what you're actually accused of doing.
Exactly. And crucially, the charge always has to mention the specific law and its section number. So, for example, it would state, Bhartiya Nagrik Sanhita 2023, Section 100.
And that's not just legalese.
Not at all. It isn't just bureaucratic detail. It's a vital shortcut for you and your legal team. You can instantly look up the exact legal provision, understand its ingredients, and see precisely what the prosecution needs to prove. It's about empowering you with immediate access to the legal framework of your case.
For most people, the idea of innocent until proven guilty is, well, it's paramount. But there's something fascinating, almost counterintuitive in the BNSS about how a charge can subtly shift a burden. Can you explain this bit about exceptions?
Yes. This is a truly powerful and perhaps surprising legal default setting in the BNSS. The charge itself inherently presumes that all the legal conditions needed to constitute the offense were met.
Okay.
And here's the key bit, that no general or specific exceptions apply unless you, the accused, prove otherwise.
Wow. Okay, so that flips things around a bit for certain defenses.
It subtly but significantly shifts the initial argumentative burden for common defenses like self-defense or provocation onto the accused.
Can you give an example?
Sure. Let me give you an illustration straight from the BNSS itself. If someone, let's call him A, is charged with murder,
Right.
the law presumes A's act falls squarely within the definition of murder under the BNS. It presumes that A's actions do not fall under general exceptions, like the right of private defense, or specific exceptions, like sudden and grave provocation, unless A explicitly provides proof for such an exception. Now, this doesn't mean you're presumed guilty. Not at all.
Okay.
It just means the prosecution doesn't have to preemptively negate every conceivable defense in the initial charge. It streamlines their initial presentation, but then it demands a proactive defense from you if you want to invoke an exception. It's quite an ingenious balancing act, really.
So this mechanism helps the prosecution avoid getting bogged down early on, while still placing the onus on the accused to raise specific justifications. And for you, as the listener, this means the system expects clarity from the outset. The charge must also be in the language of the court, ensuring accessibility. And here's a really critical safeguard. If a previous conviction could lead to a harsher punishment,
Enhanced punishment, yeah.
that fact, along with the date and place of the conviction, must be stated in the charge right from day one.
Absolutely vital.
This prevents you from being ambushed later by your past record being used against you for sentencing. Full notice from the get-go.
Yeah.
Now, beyond just naming the crime, the BNSS demands granular detail, doesn't it? It's not enough to just say, you committed a crime. The law wants to pin down the who, what, when, and where.
Exactly. Section 235 mandates specific particulars like the time, the place, and the victim or the thing involved. This is all about providing reasonable notice to you, the accused.
Makes sense.
Think about it. How can you possibly provide an alibi or counter an accusation effectively if you don't know the exact time and place the alleged incident occurred? Vague accusations can seriously prejudice your defense.
And you give a scenario.
Let's take one from the BNSS. If X is accused of stealing a specific gold necklace from Y's house on a particular date and at a particular time, those precise details, the date, the time, the specific item, the location, are critical and must be mentioned in the charge. You need to know when to check your alibi and where to confirm your presence to effectively counter the accusation. Without that kind of specificity, your ability to prepare a defense would be severely hampered.
That makes perfect sense.
Yeah.
But I remember seeing something specific for financial crimes in the outline. How does the BNSS handle those? Because tracking every single transaction in a large-scale fraud case could be, well, a nightmare.
That's a very practical observation. And the BNSS has a really ingenious tweak for financial crimes, like criminal breach of trust or misappropriation of money or property. It addresses a huge practical hurdle. Instead of prosecutors having to list every single fraudulent transaction, which, as you say, could be hundreds or even thousands, the law recognizes this difficulty. It says it's sufficient to state just the gross sum involved or describe the property and the period crucially. This period cannot exceed 1 year during which the offense occurred. You don't need to detail every single transaction within that period.
That seems like a very practical solution.
Yeah.
But does limiting that period to 1 year ever become a constraint for prosecutors dealing with really long-running, complex financial frauds?
It's definitely a balance. The 1 year limit helps prevent charges that are too vague and broad, ensuring some level of specificity for you.
Okay.
For frauds that span longer periods, prosecutors might need to frame multiple charges, each covering a specific 1 year window. But the core benefit for you, the accused, is that it prevents an information overload for both the defense and the court. It still ensures adequate notice of the total amount and time frame without getting lost in endless micro details. It's a nod to modern financial complexity.
Right, okay. Now, sometimes the how you did something is just as important as the what. This seems like another crucial safeguard for the accused.
It absolutely is. Section 236 comes into play when simply stating the offense under the previous sections isn't enough to give you adequate notice to prepare your defense.
So for some crimes, just naming it isn't enough.
Exactly. For straightforward offenses like simple theft, the manner might be obvious. Saying a stolen article at a certain time and place is usually sufficient. But for more complex crimes, like cheating or giving false evidence, detailing how it was done is absolutely vital.
Can you give examples from the BNSS?
Sure. The illustrations are very clear. If someone's accused of cheating, the charge must set out how they cheated. Merely saying a cheated bee just isn't good enough.
Right.
Similarly, if the charge is about giving false evidence, it must set out the specific portion of the evidence alleged to be false. Interestingly, for murder, the BNSS illustration actually states the manner need not be explicitly stated.
Oh, that's surprising.
It is, though in practice, prosecutions often include it for clarity anyway. It highlights a kind of nuanced legal interpretation based on the nature of the crime and how much detail is needed to avoid prejudicing you. It's about ensuring you're not left in the dark about the exact conduct being challenged.
That's like a secret code then. Legal words in a charge aren't just everyday words. They have a very specific meaning within the law itself.
That's an excellent analogy. What's crucial here is Section 237, which ensures consistency. It mandates that terms used in a charge are interpreted according to their precise definition in the relevant penal law, the BNS, usually not just a common dictionary meaning.
So for the listener.
For you, the listener, this means if a charge uses the term theft, it refers to theft as defined in the BNS, with all its specific legal ingredients like dishonest intention or moving of movable property out of the possession of any person without that person's consent. This isn't just semantics, it's fundamental to the precise application of law. It prevents misunderstandings. For example, if a charge says culpable homicide, that term must be understood exactly as defined in the BNS, including its, intricate distinctions from murder. It provides a clear, unambiguous framework for everyone involved. Ensures everyone's on the same legal page.
Okay, that makes sense. So what happens if there's a mistake in the charge? A typo, an omission? Does the whole case just fall apart, or is there some flexibility built in?
This raises a really important question about balancing sort of legal technicalities with substantive justice. Section 238 embodies a crucial principle here. Errors or omissions in stating the offense or its particulars are not automatically fatal to the proceedings.
Okay, that's good to know.
They are only considered material if two conditions are met. First, you, the accused, were actually misled by the error or omission.
Right.
And second, this resulted in a failure of justice. The core test is direct, tangible prejudice to you.
Can you illustrate that?
Yes, the BNSS provides very practical illustrations. For instance, if you're charged with possessing counterfeit coin, knowing it to be counterfeit, but the word fraudulently is accidentally left out of the charge, this error isn't considered material unless you can show you were actually misled by that specific omission. Or if the manner of cheating is omitted, but you still defend yourself effectively, maybe you call witnesses. The court might infer there was no material error because you weren't actually hampered in your defense.
Okay.
And here's a critical one. Imagine you're charged with murdering Koda Baksh on January 21st, but the victim was actually Haidar Baksh, murdered on January 20th.
Big difference.
Huge difference on paper. But if the entire inquiry and the subsequent trial focused exclusively on the murder of Haidar Baksh,
I see where this is going.
the court may infer that you were not actually misled by the incorrect name and date in the formal charge, and thus the error would be deemed immaterial. It highlights the judicial focus on actual prejudice rather than just technical flaws.
So essentially, this section acts as your shield. It ensures you understand and can defend against the actual facts of the case, rather than letting cases collapse on minor errors that didn't really affect your ability to get a fair trial.
Precisely. Substance over pure form, as long as fairness is maintained.
Okay, so we have the charge set.
Yeah.
But justice isn't static, right? Yeah. Evidence emerges during a trial, unexpected things come up, and sometimes that initial charge might need to change. How does the law handle that? How does it ensure fairness when the goalposts, so to speak, move?
This is where the inherent flexibility of the court system meets your fundamental right to a fair defense. Section 239 of the BNSS provides a vital mechanism. It allows the court to alter or add to any charge at any time before judgment is pronounced.
Any time before judgment. That's a wide window.
It is. It emphasizes the need for continuous judicial oversight and ensures that the charges accurately reflect the evidence that emerges as the trial unfolds. But, and this is key, this power must be exercised judiciously, always prioritizing your right to avoid prejudice.
How does it ensure that?
Well, for instance, every alteration must be read and explained to you, the accused. And this can even happen through audio-video electronic means now.
Okay.
It reinforces that this isn't some silent change happening behind the scenes. You need to be informed and understand it fully.
And what are the consequences if a charge is altered mid-trial?
The consequences are carefully managed to mitigate any potential prejudice. If the court believes that proceeding immediately won't likely harm either side, it can continue with the trial. However, if prejudice is likely, the court must take action. It must either direct a completely new trial on the altered charge or adjourn the existing trial for a period necessary to allow the parties, especially you, to adapt your strategy.
That sounds like a critical safeguard.
It absolutely is. For example, say you're initially charged with voluntarily causing hurt, simple hurt. But during the trial, evidence surfaces pointing towards grievous hurt by dangerous weapons, a much more serious charge. The charge can be altered, but in such a scenario, An adjournment would almost certainly be granted. You'd need time to prepare a new defense to that more serious accusation.
Makes sense.
Furthermore, if the altered charge is one that requires a prior sanction for prosecution, maybe it involves a public servant. The case cannot proceed until that necessary sanction is obtained, unless it was already obtained for the same set of facts. This upholds statutory safeguards and ensures due process isn't bypassed.
Okay, so if the charge changes, potentially significantly, your entire defense strategy might need an overhaul. How do you get to challenge these new accusations, especially if witnesses have already testified based on the old charge?
That's a very direct procedural right that flows logically from Section 239, the power to alter charges. Section 240 covers this. When a charge is altered or added,
Yes.
both the prosecution and you, the accused, have the right to recall or resummon any witness who has already been examined. This allows for specific questioning focused on the alteration. You can also call new witnesses if they become relevant due to the modified charge. This ensures a fair trial by allowing parties to adapt their evidence and arguments to the new situation.
So, using your earlier example, if a theft charge becomes robbery.
Exactly. Witnesses could be recalled to testify specifically about the element of force or threat that distinguishes robbery from simple theft, something that might not have been fully explored under the original charge.
Is this right to recall witnesses absolute?
It's a strong right, but not entirely absolute. The court can refuse to recall a witness, but only if it records specific reasons in writing stating that the request is being made merely for vexation, delay, or defeating the ends of justice.
So basically to prevent abuse of the process.
Precisely. It prevents using the recall mechanism simply to stall the trial. But for you, the listener, this means the law acknowledges the dynamic nature of trials. It builds in robust mechanisms to ensure your defense isn't undermined by changes that happen during the proceedings. It's that careful balance again between flexibility and fundamental fairness.
Okay, let's shift gears a bit. Imagine someone commits several different offenses, maybe over a period of time. Does that always mean a separate trial for each one? Or can they be grouped together, perhaps, for efficiency?
That raises a really important question, doesn't it? Balancing fairness for the accused with, the practicalities of judicial efficiency. Section 241 of the BNSS establishes the general rule, the baseline: one offense, one charge, one trial.
One trial per crime, basically.
Yes, the default. The purpose behind this is primarily to prevent prejudice and confusion for you, the accused. You could be completely overwhelmed if facing too many disparate accusations in a single proceeding. So, for every distinct offense, there should ordinarily be a separate charge, and each charge should be tried separately.
For example,
a theft committed on one occasion and an incident of causing grievous hurt on a completely different occasion must be separately charged and tried. They're distinct events, distinct crimes.
Right.
However, the BNSS then very intelligently carves out exceptions where joining charges or even joining accused persons makes practical sense, but only if it doesn't compromise fairness. Interestingly, you, the accused, can even make a written application asking for a joint trial for multiple charges if the magistrate thinks it won't cause prejudice. So there's flexibility.
That seems like a common sense grouping, though.
Yeah.
If someone keeps committing the same type of crime, maybe multiple thefts, why have entirely separate trials for each one? Seems inefficient.
What's clever here is how the BNSS balances that exact thought in Section 242. It introduces a key exception allowing the joinder of up to 5 offenses of the same kind.
Why?
Committed by the same person within a 12-month period. The identity of the victim, by the way, is irrelevant here. What matters is the nature of the offense and the time frame.
And what defines same kind?
Offenses are of the same kind if they are punishable with the same amount of punishment under the same section of the BNS or any special or local law. The BNSS even has specific provisos clarifying this. For instance, certain types of theft are explicitly grouped together as being of the same kind. Attempts are also covered.
So give me a scenario.
Okay. Say X commits 3 separate thefts, maybe shoplifting incidents, all falling under Section 3032 of the BNS, over an 8-month period. X can be charged and tried for all 3 thefts in one single trial.
Right. That streamlines things.
Exactly. It streamlines the process for repetitive similar crimes and saves valuable judicial resources while ensuring you, if you were X, know exactly what period of alleged activity is under scrutiny.
But what if the crimes are linked? Part of a single story, perhaps, even if they're different types of offenses, like, say, a robbery followed by an attempt to bribe a witness.
Now you're touching on Section 243. This raises the important question. When do seemingly distinct acts become part of a larger narrative? This section focuses heavily on the interconnectedness of offenses.
Interconnectedness. How is that defined?
The most crucial concept here is same transaction. If multiple offenses, even different ones, are committed by the same person in one series of acts so connected as to form the same transaction, they can be tried together.
What constitutes the same transaction? That sounds a bit vague.
The courts have developed pretty clear tests for this over time. They look at factors like proximity of time and place, continuity of action, and whether there was a shared community of purpose or design linking the acts. It does require careful judicial assessment of the specific facts in each case.
Can you illustrate that?
Let's look at the BNSS illustrations again. Imagine someone, A, rescues a prisoner, B, from custody, and in the process of doing so, A causes grievous hurt to C, the constable guarding B.
Okay, two distinct offenses. Rescuing a prisoner and causing grievous hurt.
Right, but these two distinct offenses can be tried together because they are clearly part of the same transaction linked by a common purpose, freeing the prisoner, and continuity of action.
I see. Any other examples?
Another specific application mentioned is for financial crimes. If a person commits criminal breach of trust, say, embezzles funds, and then falsifies accounts to try and hide it, both the breach of trust and the falsification of accounts can be tried together because they're interconnected actions with a common design.
Okay.
The law also covers scenarios where a single act falls under two or more legal definitions. For example, an act that constitutes both assault and causing grievous hurt. In such a case, you can be charged and tried for each such offense.
Right.
Similarly, if several acts, which are individually offenses, also combine to form a different, larger offense, like, say, housebreaking committed with the intent to commit rape, you can be charged for both the individual act of housebreaking and the combined, more serious offense.
But you can't be punished twice for the same act, right?
Absolutely not. It's vital to remember that while you can be tried for multiple charges arising from the same facts under these provisions, Section 9 of the BNS prevents double punishment for the exact same criminal act. So conviction might happen on multiple counts, but sentencing has to account for that.
Okay, that's clear. Now, sometimes even the best investigators might look at a set of facts and not be 100% sure exactly which specific crime fits perfectly.
Yeah.
How does the law handle that kind of initial uncertainty?
What's fascinating here is the very pragmatic approach the BNSS takes in Section 244. It provides flexibility for the prosecution when there's genuine doubt. If a single act or a series of interconnected acts could plausibly constitute several different offenses, you, the accused, can be charged with having committed all or any of those offenses, or even charged in the alternative. This ensures that justice isn't derailed simply because of initial uncertainty about the precise legal category the facts fall into.
So you could be charged with, say, theft or
Yeah.
receiving stolen property.
Exactly. Or theft, receiving stolen property, criminal breach of trust, and cheating if the facts could potentially support any of those interpretations. The charge can list them all, or frame it as committed offense A, or alternatively offense B. This allows the court to ultimately decide which one, if any, is proven by the evidence presented during the trial.
And here's a key point from the outline. What if you're charged with just one offense, but the evidence proves a different one?
Critically, Section 244 allows for this. If you're charged with one specific offense, but the evidence presented during the trial actually proves a different offense for which you could have been charged under this flexible section,
Right.
you can be convicted of the offense that is proven by the evidence, even if you weren't formally charged with it.
Wow. That seems potentially unfair, like a surprise conviction.
There is a crucial caveat. This is only allowed if you had adequate notice of the facts constituting the proven offense through the evidence presented, and you are not prejudiced in your defense because of the discrepancy in the charge. It protects against genuine surprise.
Okay, so if you're charged only with theft, but the evidence convincingly shows it was actually criminal breach of trust, based on the same core facts presented.
You can still be convicted for criminal breach of trust, provided you weren't unfairly hampered in defending against those facts. This provision helps avoid purely technical acquittals where the true nature of the crime is proven, but it didn't perfectly match the initial charge label.
Okay, I get it. Now, what if the prosecution aims high, charges a major offense, but only manages to prove a lesser version of it? Does the accused just walk free?
No, and this is another crucial aspect of preventing miscarriages of justice, covered in Section 245. The BNSS allows conviction for a minor offense if the major offense charged isn't fully proven, but the essential elements or ingredients of that minor offense are clearly established by the evidence.
What constitutes a minor offense here? Just less jail time?
It's not just about lesser punishment, though that's often the case. It's more about its legal ingredients being inherently embedded within the major offense charged. For instance, if a charge consists of several particulars, several elements,
Yeah.
and only some of those particulars are proven, but those proven particulars themselves form a complete, distinct minor offense, then you can be convicted of that minor offense, even if it wasn't separately charged.
Can you give an example?
Sure. The BNSS illustrations are helpful. If you're charged with a specific aggravated form of criminal breach of trust, maybe by a carrier or banker, but the evidence only proves general criminal breach of trust,
Okay.
you can be convicted of the general minor offense. Or another example, if you're charged with causing grievous hurt, but the evidence proves you acted on grave and sudden provocation, you can be convicted of the lesser offense of causing grievous hurt on provocation.
And attempting a crime counts too.
Yes. You can be convicted of an attempt to commit an offense even if the attempt itself wasn't separately charged, if the main charge fails but the attempt is proven.
Are there any limitations?
Yes, an important one. This flexibility cannot be used to bypass requirements for initiating proceedings. For example, if the minor offense requires a specific sanction to prosecute, and that sanction wasn't obtained, you can't be convicted of it under this section.
So again, it ensures justice focuses on what the facts actually prove, rather than getting caught up in the initial charge being slightly off.
Exactly. It prevents technical escapes when a related lesser crime is clearly established.
Finally, for this section, let's talk about who gets to stand trial together. If two or more people are involved in criminal activity, are they always separate cases, or can they be grouped in one trial?
This is where Section 246 comes in, consolidating trials for efficiency and, importantly, to avoid potentially conflicting decisions that could arise from separate trials dealing with the same or connected events. The BNS specifies several categories of persons who may be charged and tried together.
What are the key categories?
Well, the most obvious is persons accused of the same offense committed in the same transaction. Think multiple people involved in a single robbery.
Right.
Also, offenders and those who abetted them or attempted the offense. Persons accused of different offenses but committed within the same transaction. Principal offenders and those who receive or conceal stolen property from them. People involved in different offenses related to the same counterfeit coin. And even persons accused of more than one offense of the same kind, as we discussed earlier, committed jointly within 12 months.
That covers quite a few scenarios. Is there any flexibility beyond these listed categories?
Yes, and this is a critical new aspect, a proviso added for flexibility. Even outside these specific categories, a magistrate or a sessions court can decide to jointly try persons for separate offenses under certain conditions.
What conditions?
The individuals involved have to apply for it in writing, the court must be satisfied that no prejudice will occur to any of them, and the court must deem it expedient in the interest of justice. This is a significant discretionary power granted to the courts.
So give me a quick example of who could be tried together.
Okay. A, B, and C together commit robbery, same offense, same transaction, joint trial allowed. Or A commits theft, and B knowingly receives the stolen property from A, different offenses, but linked receiver-offender relationship, joint trial allowed.
Got it. So for you, the listener, this section shows how the legal system strategically groups cases. It prevents multiple repetitive trials covering the same ground, saving time and resources, while always keeping an eye on guarding against unfairness by ensuring there's a clear common thread in the alleged criminal activity being tried together.
Precisely. Efficiency balanced with fairness.
Okay, now let's step into the courtroom itself. Specifically, let's talk about trials before a court of session. These are generally reserved for the most serious cases, right? What does that process look like under the BNSS? How is it structured?
Yes. When we connect this to the bigger picture, trials before a court of session really represent the apex of a criminal proceeding. They often deal with grave offenses like murder, rape, serious organized crime offenses carrying significant punishments. Chapter 19 of the BNSS outlines a very structured, meticulous process for these trials.
Meticulous how?
Well, it ensures every step, from the prosecutor's opening remarks right through to the final judgment, adheres to strict legal standards. This structure includes important checks and balances. We'll talk about things like the opportunity for a discharge application early on,
Right.
and critically, a bifurcated sentencing process. That's a key feature designed to safeguard your rights and ensure justice is not just served, but clearly seen to be served, especially when severe punishments are possible.
Let's start with something practical. If you're facing several serious charges in a sessions trial, and you get convicted on one or maybe two of them, do the prosecutors still have to pursue all the others? Or can some be dropped at that point?
That raises a really important question about the practicalities of prosecution and achieving some finality in complex cases. Section 24(7) allows the prosecution, with the court's consent, to withdraw the remaining charges if a conviction has already been secured on one or more charges in the same trial.
The court has to agree.
Yes, consent is needed. The court can also, on its own initiative, decide to stay the inquiry or trial into these remaining charges. This withdrawal or stay effectively acts as an acquittal for those specific charges unless the conviction is later overturned.
Why would they do that?
It's often used when the sentence already imposed for the proven charges is substantial enough to meet the ends of justice. It avoids unnecessary prolongation of litigation on charges that might not significantly alter the overall outcome or punishment. It provides a measure of finality.
But what if that initial conviction gets overturned on appeal? Are those withdrawn charges just gone forever?
No, there's a crucial revival clause built in. If the initial conviction is later set aside, maybe by an appellate court, the withdrawn charges can be revived and proceeded with. This ensures that justice is fully pursued if the initial outcome is found to be flawed.
Okay, that makes sense. Now, in these very serious trials, who actually argues the case for the state? What's their specific role defined by the BNSS?
What's fascinating here, and really central to the process, is the distinct role of the public prosecutor, or PP Section 248, mandates that every trial before a court of session shall be conducted by a public prosecutor.
Why is that so important?
It's crucial because the PP isn't supposed to be simply a persecutor, solely aiming for conviction. They are designated as an officer of the court, often referred to as a minister of justice. Their primary duty is to assist the court in arriving at the truth, ensuring fair play for all parties involved, including you, the accused.
So they're meant to be independent.
Ideally, yes. Independent, not merely a mouthpiece for the police or the investigating agency. Their role is to present all relevant evidence objectively, both the evidence that points towards guilt and any evidence that might point towards innocence. Fairness and truth-seeking are paramount.
Okay, so when the trial formally begins, after all the preliminaries, what's the very first thing that happens in the courtroom? How does the case kick off?
This is laid out in Section 249. It's essentially the prosecution laying out its roadmap for the entire trial. The public prosecutor begins by describing the charge brought against the accused,
Right.
and then states what evidence they propose to present to prove the accused's guilt. This opening statement is vital. It gives both the court and you, the accused, a clear overview of the specific allegations and the type of evidence. Will it be eyewitness testimony, forensic reports, documents, digital evidence that they intend to use to substantiate those charges?
So it helps you understand the case you have to meet.
Exactly. It helps you understand the broad contours, the main thrust of the prosecution's case, allowing you to focus your defense strategy right from the start.
Now, is there a way to avoid going through a full, potentially very long and arduous sessions trial if the evidence against you just isn't strong enough, even before the trial really gets going?
Absolutely. And this is a critical pretrial remedy provided under Section 250. The judge is empowered to discharge you, the accused, right after considering the initial case record, the documents submitted by the prosecution, and after hearing arguments from both sides.
On what grounds?
If the judge finds not sufficient ground for proceeding against the accused, this acts as a vital filter. It prevents you from having to endure the rigors of a full trial if the prosecution's case, even looking at just their own investigation material, is fundamentally baseless or doesn't raise enough suspicion.
Is there a time frame for seeking this?
Yes. You can specifically apply for this discharge within 60 days from the date the case was committed to the Sessions Court. It provides a clear window for this important safeguard.
What's the test the judge applies? Is it like a mini trial?
No, it's not a mini trial. The judge isn't weighing the evidence in detail at this stage. They review the material submitted to see if a prima facie case exists. Basically, is there some initial evidence that, if believed, could potentially lead to a conviction? If the evidence only raises a mere suspicion, but not what the law calls grave suspicion, meaning there isn't enough initial material to reasonably suggest a crime might have been committed by you, then discharge is warranted, and the judge must record detailed reasons for doing so. It protects you from unwarranted prosecution.
Okay, so if you're not discharged, if the judge thinks there are sufficient grounds to proceed, what's the next formal step that moves the case towards a full trial?
If the judge finds that a prima facie case exists, meaning there's enough initial evidence to reasonably proceed with the trial, then the next step under Section 251 is the formal framing of the charge.
This is the definitive accusation.
Yes. This marks the precise formal accusation upon which the trial will proceed. Now, what's particularly notable here is a kind of two-tiered approach based on the type of offense.
How so?
If the offense is serious but not exclusively triable by a sessions court, the judge has the option to frame the charge and then transfer the case down to a Chief Judicial Magistrate, CJM, or a Judicial Magistrate First Class, JMFC, for the actual trial. This is a practical measure, really, to distribute the judicial workload effectively.
And if it is exclusively triable by the Sessions Court?
Then the sessions judge shall frame a written charge. And there's a timeline here, too. This should happen within 60 days from the date of the first hearing conducted on the charge. This aims to expedite the process.
And after the charge is framed?
After framing, the charge must be read out and explained clearly to you. The accused, and again, this can now happen via audio, video, electronic means, you are then formally asked whether you plead guilty to the offense charged or if you claim to be tried, meaning you plead not guilty. This ensures you fully understand the accusation you face and what the prosecution intends to prove before the trial proper begins.
What if someone at that point simply says, yes, I did it? Is that an automatic conviction?
This is covered in Section 252. If you, the accused, plead guilty to the offense charged, the judge shall record your plea. That's mandatory recording. However, the judge then has the discretion whether or not to convict you based solely on that plea.
So it's not automatic. Why the discretion?
The discretion is crucial. It means it's not an automatic conviction. The judge must ensure the plea is truly voluntary, unequivocal, meaning clear and unambiguous, and made with a full understanding of the serious consequences, especially in sessions cases which involve grave offenses. The court's role is to ensure the plea is genuine and that justice is served not just to rubber stamp an admission, particularly if there are doubts about its voluntariness or clarity.
Okay, so assuming you plead not guilty, where the judge decides not to convict on a guilty plea, the real trial begins, right?
Yeah.
What happens then when the prosecution presents its side? How does that unfold?
Precisely. If you plead not guilty, or if the judge doesn't convict on a guilty plea, Section 253 mandates that the judge shall fix a date for the examination of prosecution witnesses.
Right.
Then, on that fixed date, or subsequent dates as needed, the court proceeds to take all the evidence the prosecution produces. This is the core of the prosecution's case. Witnesses are called examined-in-chief by the prosecutor.
Be cross-examined by the defense.
Exactly. Cross-examined by your defense team, and then potentially re-examined by the prosecution on matters arising from cross-examination.
And technology plays a role here, too.
Yes, Section 254 explicitly mentions that the evidence of witnesses, particularly public servants, may be recorded via audio, video, electronic means at designated places. This reflects a significant step towards leveraging technology for efficiency, potentially reducing delays and travel burdens.
Is there flexibility in how witnesses are examined?
Yes. The judge retains discretion. They can permit the cross-examination of a witness to be deferred until a later stage, or recall any witness for further examination or cross-examination if needed. This ensures fairness in managing complex evidence and allows for adaptations as the trial progresses, a key right for your defense to effectively challenge the prosecution's case.
Okay. Now, can a case end and you be acquitted even before the defense gets a chance to present its side? Is there a point after the prosecution finishes where the judge can say there's just no case here?
Yes, there is. Section 255 provides for this possibility. After the prosecution's entire evidence has been presented, after you, the accused, have been examined by the court, if the court deems it necessary, and after hearing arguments from both sides specifically on this point,
Yes.
if the judge finds that there is no evidence that you committed the offense, the judge shall record an order of acquittal.
No evidence. That sounds like a high bar.
Right.
Higher than the discharge stage.
It is a higher threshold than the not sufficient ground needed for an early discharge. No evidence at this stage means a total lack of incriminating evidence connecting you to the crime, even after the prosecution has put forward its entire case. If there is any credible evidence, however weak it might seem at that point, the trial would typically proceed to the defense stage. But if the prosecution's case completely fails to establish any link between you and the crime, an acquittal can be recorded right then, preventing further unnecessary proceedings.
So if the prosecution's case does hold up, at least enough to proceed, then it's finally your turn to tell your story, isn't it? What rights do you have to present your defense under the BNSS?
What's fascinating here and really fundamental to the process is how robustly Section 256 enshrines your right to a full and fair defense. If you're not acquitted under Section 255,
Right.
you are formally called upon to enter on your defense and adduce any evidence you may have in support of it.
What does that entail? What can you do?
It includes a multitude of options. You can choose to submit a written statement detailing your defense, if you wish.
Okay.
You can lead oral evidence by calling your own witnesses. You can produce documentary evidence. And, crucially, you can request the court to issue process summonses to compel the attendance of your witnesses for examination or cross-examination, or to compel the production of any documents or things relevant to your defense.
Does the court have to grant these requests to summon witnesses or documents?
The court shall issue such process unless the judge considers, for reasons that must be recorded in writing, that the request is made merely for the purpose of vexation, delay, or defeating the ends of justice. So, barring attempts to abuse the process, the court is obligated to assist you in bringing your evidence forward. This ensures you have a fair and comprehensive opportunity to rebut the prosecution's case and present your side fully with the court's assistance if needed.
Okay, so after all the evidence is out, prosecution side, defense side, it's time for the lawyers to make their closing arguments, right? Sum everything up.
Exactly. Section 257 covers the arguments stage. When the examination of all witnesses for the defense is complete, the process typically unfolds like this. The prosecutor first sums up his case. They'll highlight the evidence they believe supports the charges and argue why you should be convicted.
And then the defense gets the last word.
Then, you or your advocate have the right to reply. You present your arguments, offer your interpretation of the evidence, point out weaknesses in the prosecution's case, highlight your defense evidence, and argue why you should be acquitted.
What if the defense raises a new legal point in their closing?
If any new point of law is raised by the defense in their reply, the prosecution can, with the judge's permission, make further submissions confined strictly to that point of law. These oral arguments are critical. They assist the court in appreciating all the complex evidence presented over the course of the trial and in applying the relevant law correctly to reach a just conclusion.
And then, after all that, comes the ultimate moment of truth, the judgment. How does that final step unfold?
Indeed, Section 258 deals with the judgment. The BNSS mandates that the judge shall give a judgment as soon as possible after the conclusion of arguments. Ideally, this should be within 30 days from the date of completion of arguments.
30 days? That seems quick.
It's an aspirational timeline, aiming for efficiency. It can be extended up to 45 days, but only for specific reasons that have to be recorded in writing. Now, what's truly a significant innovation here, and quite fascinating legally, is the bifurcated process if you are found guilty.
Bifurcated, meaning split in two.
Exactly. First, the judge pronounces the finding of guilt a clear declaration of whether the prosecution has successfully proven its case beyond reasonable doubt. That's step one.
And step two.
Then, separately, a specific hearing is held solely on the question of sentence. This gives you, the convicted person, a crucial opportunity after guilt has already been established to present any mitigating circumstances. You can bring forward details about your personal background, family situation, health, maybe express remorse, or raise any other factors relevant to deciding the appropriate punishment before the sentence is actually decided.
Why is this separation so important?
It ensures a more just and proportionate sentence is ultimately passed according to law. It allows for a focused discussion on the human elements of punishment, separate from the determination of guilt, giving your voice weight in that critical decision.
We talked earlier about previous convictions potentially being mentioned in the charge, specifically for getting an enhanced punishment. When does that actually come into play during the trial itself, so it doesn't unfairly prejudice the main question of guilt?
Yes. Section 259 addresses this very important point about preventing prejudice. The BNSS outlines a very strict procedure when a previous conviction is relevant for enhanced punishment and has been stated in the charge.
What's the procedure?
Evidence regarding this previous conviction is only taken after you've been convicted on the current substantive offense being tried. Critically, the part of the charge relating to the previous conviction is not read out to you at the beginning, nor are you asked to plead to it initially. And the prosecution absolutely cannot refer to it or adduce any evidence about it unless and until you've been found guilty of the current offense.
So it completely isolates the two issues.
Absolutely. It isolates the determination of guilt for the current trial from your past record. This ensures fairness in determining guilt for the present charge, making your previous history relevant only for the sentencing phase, after conviction. It's a fundamental aspect of fair play, preventing your past from tainting the assessment of the current facts.
Before we leave Sessions trials, are there any specific types of cases that get a unique procedural twist in the Sessions Court, perhaps due to their sensitive nature or the individuals involved?
Yes, Section 260 provides a distinct procedure, which is quite fascinating, specifically for defamation cases brought against high public functionaries. We're talking about the president, vice president, governor, administrator of a union territory, or minister of the union or a state or UT.
Okay, defamation against top officials. How is it different?
When cognizance is taken by a court of session upon a complaint filed by the public prosecutor alleging such defamation, while it's tried by a sessions court, it actually adopts the procedure of a warrant case instituted otherwise than on a police report. A procedure we'll discuss next, but with its own specific adaptations.
What are the key features?
Key features include the option for in-camera trials if desired by either party or if the court deems it appropriate in its discretion. This protects the dignity of the office involved and ensures privacy.
Anything else?
Significantly, the court has the power to award compensation to you, the accused public functionary, up to 5,000 rupees, payable by the person against whom the plea of justification was made if the court finds the accusation was made without reasonable cause or was frivolous or vexatious.
So a deterrent against baseless complaints.
Exactly. It acts as a deterrent against frivolous complaints targeting public figures, ensuring the special procedure isn't misused for harassment, while also offering some financial redress if the accusation is proven baseless.
Yeah. Okay. Moving down from the very serious cases handled by sessions courts, let's explore warrant cases tried by magistrates. These are still significant cases, but the procedure has some distinct features compared to sessions trials, right?
Indeed. Chapter XX of the BNSS outlines the procedure for warrant cases tried before magistrates. Generally, these involve offenses punishable with imprisonment for a term exceeding 2 years, so they're more complex and serious than summons cases, which we'll get to later.
And what's the key distinction here?
What's fascinating within this chapter is the careful distinction the BNSS makes between cases initiated based on a police report, like a charge sheet after investigation, versus those initiated otherwise than on a police report, typically a private complaint filed directly by a citizen. Each pathway has its own tailored procedural safeguards designed to ensure fairness for you, the accused, reflecting the different ways the evidence and allegations initially come before the court. It's about adapting the process to the source of the complaint.
Right, let's start with the more common route. Cases initiated by the police filing a charge sheet. What's the very first step the magistrate takes when that case lands on their desk?
Section 261 mandates a crucial preliminary check right at the very beginning. Before anything else, the magistrate must satisfy himself that copies of all the relevant documents relied upon by the prosecution have been supplied to you, the accused.
What kind of documents?
We're talking about the police report itself, the first information report, FIR, any statements of witnesses recorded by the police during the investigation, under Section 180, any confessions or statements recorded by a magistrate, any documents seized, basically everything the prosecution plans to use.
Why is this step so important?
It's absolutely fundamental for you to prepare an effective defense. You need to know the evidence being marshaled against you before the trial even properly commences. The magistrate's duty to ensure this disclosure happens reinforces your fundamental right to a fair trial. It's like being handed the prosecution's playbook before the game starts.
Okay, similar to the sessions court procedure, can you get out of a magistrate's trial early in these police report cases if the case against you looks weak or lacks substance from the start?
Yes, and this is another vital check against unfounded prosecutions covered in Section 262. The magistrate is empowered to discharge you if, after considering the police report and all the documents submitted with it, and after giving both the prosecution and you an opportunity of being heard,
Yes.
the magistrate considers the charge against you to be groundless.
Groundless. What does that mean in practice?
It means there's no prima facie basis for the accusation. Even taking the prosecution's material at its highest value, it doesn't reveal sufficient grounds for proceeding with the trial. Maybe the evidence is contradictory or simply doesn't connect you to the alleged crime.
Is there a time frame to ask for this?
Yes, mirroring the sessions procedure, you can apply for this discharge within 60 days from the date you received those initial documents from the prosecution. And if the magistrate does decide to discharge you, they must record their reasons in writing, ensuring transparency and accountability for such a significant decision that protects you from unwarranted legal proceedings.
Okay, so if you're not discharged, if the magistrate believes there's a case to answer, what happens next? Does the formal accusation come then?
Precisely. If the magistrate finds there is ground for presuming you've committed an offense they are competent to try and can adequately punish, then under Section 263, they shall frame a formal written charge against you.
And is there a deadline for this?
Yes. Again, aligning with the push for efficiency, this charge must be framed within 60 days from the date of the first hearing conducted on the charge. This formalizes the accusation and clarifies the specific legal parameters for the trial ahead.
What happens after it's framed?
The charge is then read out and explained clearly to you, and you are formally asked whether you plead guilty to the offense charged or if you claim to be tried. Plead not guilty. This ensures you fully comprehend the specific allegations you are now officially facing. This is where the case truly solidifies and moves towards trial.
Again, that question about guilty pleas. If someone admits guilt at this stage before the magistrate, is it an automatic conviction or is there still judicial oversight?
What's interesting here is the consistency with the sessions trial procedure. Section 264 states that if you plead guilty, the magistrate shall record your plea. That's mandatory. However, the magistrate may, in their discretion, convict you based on that plea.
The discretion is key again.
Yes. It ensures the plea is truly voluntary, informed, and not made under any duress or misunderstanding. If the magistrate isn't satisfied, perhaps the plea seems ambiguous or coerced, they won't convict solely on the plea and will proceed as if you pleaded not guilty. But if satisfied, it allows for an efficient resolution, saving judicial time, while still upholding justice by preventing an unfair conviction.
Makes sense. So if you plead not guilty, how does the prosecution then present its entire case to the magistrate in a warrant case based on a police report?
Under Section 265, the magistrate fixes a date for the examination of prosecution witnesses. On that date, the prosecution presents all its evidence. A crucial safeguard here, reinforcing the initial disclosure, is that the magistrate shall, before examining witnesses, supply you with copies of the statements of those prosecution witnesses recorded during the police investigation.
Why is that timing important?
It's vital for effective cross-examination. It enables you and your lawyer to prepare your questions knowing exactly what the witness has previously stated to the police, allowing you to probe inconsistencies or highlight contradictions.
And technology. Audio, video.
Yes, the provision for potentially recording witness examination via audio-video electronic means at designated places applies here too, reflecting that push towards modernizing the process across different trial types. The magistrate also retains discretion to permit deferring cross-examination or recalling witnesses, ensuring flexibility and fairness in managing the evidence flow. That's an important right for your defense.
Okay, and then after the prosecution has put forward all its evidence, it's your turn to present your defense to the magistrate.
Yes, absolutely. Section 266 kicks in then. You are formally called upon to enter on your defense and adduce any evidence you may have.
Same rights as in Sessions Court, basically.
Very similar. This includes submitting a written statement if you choose, calling your own witnesses for oral evidence, producing documents, and requesting the magistrate to summon your witnesses or compel document production. The magistrate shall issue such process unless, again, the request is deemed vexatious for delay or to defeat justice with reasons recorded. It ensures your fundamental right to present your side fully, with the court's help if needed. And yes, electronic means can potentially be used for defense witnesses too, further streamlining things.
Okay, that covers cases starting from a police report. But what if it's not the police? What if it's a private citizen who files a complaint directly with the magistrate? How does that process differ? It sounds like the starting point is quite different.
You're right, the starting point is different, and that significantly impacts the initial procedure under Part B of this chapter, because there's no prior police investigation report with collected evidence and witness statements.
Right, the magistrate is starting fresh.
Exactly. So, in these complaint cases, Section 267 says the magistrate first proceeds to hear the prosecution, which is essentially the complainant, and any witnesses they bring, and takes all the evidence they produce after you, the accused, appear in court following the summons. This means you hear the evidence against you for the very first time directly in the courtroom as it's presented by the complainant.
That's a big difference from getting police statements beforehand. So In these private complaint cases, are there still opportunities for an early discharge if the case seems weak? Maybe even more chances.
What's fascinating here is the layered protection the BNSS provides in Section 268 for complaint cases. The magistrate can discharge you in two distinct scenarios.
Two. Okay.
First, if, after taking all the prosecution evidence, the complainant's evidence, and examining you if necessary, the magistrate finds that no case has been made out against you, which, if it remained unrebutted, would warrant your conviction. If the complainant's own evidence doesn't even make a basic case, you shall be discharged, with reasons recorded.
And the second scenario?
Second, and this provides an even earlier potential exit, the magistrate can discharge you at any previous stage of the case if they consider the charge to be groundless, meaning even before all the complainant's evidence is heard, if it becomes clear the complaint lacks any prima facie basis, the magistrate can discharge you. This ensures that if a case is clearly baseless from the outset or its baselessness becomes apparent early on, it can be terminated quickly, saving you from prolonged, unwarranted legal proceedings initiated by a private party.
Okay, so if you're not discharged in a complaint case, what's the specific sequence when a formal charge is eventually made? It sounds a bit different.
It is quite unique, laid out in Section 269. If, after considering the complainant's evidence, the magistrate thinks there is ground for presuming you've committed an offense they can try, they first frame a formal written charge against you. After that charge is read and explained, and you plead to it, guilty or not guilty, a crucial right kicks in specifically for complaint cases. You are then explicitly asked if you wish to cross-examine any of the prosecution witnesses whose evidence has already been taken.
Ah, because you heard them for the first time in court.
Exactly. This addresses the fact you didn't get prior statements. If you do wish to cross-examine, those named witnesses are recalled specifically for your cross-examination and then potentially re-examined by the complainant, after which they are discharged.
What about any other prosecution witnesses the complainant still wants to call?
The evidence of any remaining prosecution witnesses is taken after this cross-examination phase. So the flow is complainant's initial evidence, charge framing, accused cross-examination of initial witnesses, remaining complainant's witnesses, defense evidence.
That seems fair, ensuring you get to challenge everything. What if witnesses just can't be found for cross-examination later?
There's a new provision addressing that potential bottleneck. It allows the magistrate to close the prosecution evidence and proceed with the case if witnesses, whose presence is necessary for cross-examination, cannot be secured despite reasonable measures being taken by the prosecution. This balances your right to cross-examine with the need for trial efficiency, preventing indefinite delays caused by unavailable witnesses.
Okay. And once all that prosecution evidence is complete, including the cross-examinations, how does your defense work in a private complaint case? Is it the same as in police report cases?
Yes. Once the prosecution evidence stage is fully complete, Section 270 makes it clear that you then get the same robust rights as in police report cases to enter on your defense and produce your evidence, exactly as outlined back in Section 266.
So same rights to make a statement, call witnesses, summon documents.
Absolutely. This ensures procedural parity for your defense, irrespective of whether the warrant case was initiated by the police or by a private complainant. The law makes sure your fundamental right to present your side comprehensively isn't compromised just because the case started differently.
Right. We've seen how both types of warrant cases proceed. How does a magistrate's warrant case trial eventually wrap up? What are the possible outcomes and concluding steps?
What's fascinating here, in Part C, is how the BNSS ensures a definitive conclusion, whether that's an acquittal, a conviction, or through special provisions handling unique circumstances like the complainant disappearing or the accusation being baseless. All these mechanisms are designed to conclude the proceedings fairly and effectively for everyone involved.
So let's start with the main outcome, the final verdict. What happens if you're found not guilty versus guilty by the magistrate?
Yes, the ultimate conclusion under Section 271. If the magistrate finds you not guilty, they shall record an order of acquittal, providing you with formal closure and exoneration.
And if found guilty?
If found guilty, the magistrate, after hearing you specifically on the question of sentence, that critical bifurcated hearing we discussed earlier.
Right, the separate hearing for sentencing.
Yes. After that hearing, the magistrate passes sentence upon you according to law, unless they feel the punishment required is beyond their power, in which case they might refer it to the CJM, or they decide to release you on probation. This structure ensures your voice is heard specifically on the matter of punishment before it's determined.
Does the procedure for proving previous convictions for enhanced punishment apply here too?
Yes, the same safeguard applies. If a previous conviction is relevant for a harsher sentence, evidence for it is only taken after you're convicted on the current substantive charge, preventing prejudice during the initial determination of guilt.
Okay, now what happens if the complainant, the person who initiated the private complaint case, doesn't show up for a hearing? Does the case just stall indefinitely hanging over your head?
Not anymore. Section 272 introduces a crucial new safeguard to prevent exactly that. If the complainant is absent on a day fixed for the hearing in a complaint-initiated warrant case,
Yes.
and the offense is one that is lawfully compoundable, meaning it can be settled amicably, like minor assault, or it's non-cognizable, meaning police can't arrest without a warrant,
Okay.
the magistrate may discharge you. Significantly, the magistrate must first give the complainant 30 days' time to appear before passing such a discharge order.
So a clear deadline for the complainant.
Exactly. It prevents indefinite harassment and promotes diligent prosecution by requiring the complainant to actively pursue their case. If they don't show up within that grace period, the magistrate can discharge you. However, if the complainant is represented by an advocate, or if their personal attendance isn't deemed necessary by the magistrate for that particular hearing, the case can still proceed.
That sounds like a strong incentive for complainants to be present or represented. But let's flip it. What if someone is dragged through court, maybe for months or years, on what turns out to be a completely false or baseless accusation in a private complaint? Can they get any compensation for that ordeal?
Absolutely. And Section 273 provides a significant deterrent against frivolous or vexatious complaints. If you are discharged or acquitted in a case instituted on a complaint or upon information given to police or a magistrate,
Yes.
and the magistrate believes there was no reasonable ground for making the accusation against you in the first place,
Okay.
they can order the complainant or the informant to pay compensation directly to you. The amount can be up to the limit of the fine the magistrate is empowered to impose.
Does the accuser get a say before the order is made?
Yes, fairness dictates that. The person who made the accusation gets an opportunity to show cause, to explain why compensation shouldn't be awarded before the magistrate makes the final order. But this provision provides a summary remedy for some financial redress for you, the wrongly accused, and perhaps more importantly, actively discourages people from filing vexatious litigation. It highlights the law's commitment to protecting you from unwarranted legal battles and ensuring accountability for those who initiate baseless proceedings.
Okay, we've covered the more serious sessions trials and the intermediate warrant cases.
Yeah.
Now let's look at what seems like the speed lane of criminal justice. Summons cases. These are generally for less serious offenses, right?
Yes, precisely. Chapter 21 of the BNSS deals with summons cases. These typically involve offenses punishable with imprisonment for a term not exceeding 2 years, so generally less serious than warrant cases.
And the procedure reflects that.
Absolutely. What's truly fascinating here is the significantly streamlined procedure. It's designed for expeditious disposal, getting these cases through the system quickly, while still maintaining the fundamental principles of fairness. The key is striking that delicate balance, achieving speed without sacrificing essential justice for you, the individual involved. It's about having an appropriate procedure for the appropriate level of gravity.
So for these less serious cases, is there no elaborate charge framing process like we discussed for warrant and sessions cases? How's the accusation presented?
What's fascinating here, and a key simplification under Section 274, is that when you appear before the magistrate in a summons case, the particulars of the offense alleged against you are simply stated to you. You're then asked whether you plead guilty or if you have any defense to make. But crucially, a formal written charge is not required to be framed.
No formal charge. That must speed things up considerably.
It does. It makes the process much quicker and less formal right from the start. And there's another significant new proviso added here. The magistrate can release you, which effectively acts as a discharge at the very outset if, after recording reasons, they consider the accusation to be groundless.
So an even earlier exit ramp than in warrant cases?
Yes, potentially right at the first appearance if the complaint seems utterly baseless. This acts as a crucial early filter against frivolous prosecutions in these minor cases, potentially preventing you from even having to undergo the initial stages of a trial. It's an immediate off-ramp if the case lacks merit on its face.
That's a great efficiency measure. Now, how does pleading guilty work in these simpler summons cases? Are there even faster options for really minor infractions like small fines?
Okay, 2 main ways. First, under Section 275, if you plead guilty in a general summons case when the particulars are stated to you, the magistrate shall record your plea as nearly as possible in your own words and may, in their discretion, convict you based on that plea. Standard procedure.
But you mentioned faster options.
Yes, here's where it gets really innovative, especially for petty cases under Section 276. If you receive a special summons for a petty offense, and this is defined specifically as an offense punishable only with a fine up to 5,000 rupees.
Okay, fine only, up to 5K.
Right. In that specific situation, you can actually plead guilty and pay the fine specified in the summons without appearing in court at all.
Really? How?
You can do this either by sending the plea and fine amount by post or messenger to the court, or you can authorize an advocate to appear on your behalf and plead guilty for you. This dramatically reduces the burden on courts dealing with high volumes of low-severity infractions, think minor traffic violations or small public order fines, and crucially, it saves you a significant amount of time and hassle. It's a very smart administrative solution.
Definitely sounds practical. So if you decide not to plead guilty in a summons case, if you want to fight the charge, what then? What does the actual trial look like?
If you don't plead guilty, or if the magistrate doesn't convict you on your plea, then under Section 277, the magistrate shall proceed to hear both the prosecution and you, the defense. They take all the evidence produced by both sides.
So witnesses can still be called.
Yes. The magistrate can also issue summons to compel the attendance of any witness or the production of any document if requested by either the prosecution or the defense, ensuring all relevant evidence is presented. This is the core trial phase, albeit conducted in a more streamlined format than a full warrant case. The procedures are quicker, but the fundamental right to present evidence and challenge the other side's evidence remains intact.
And how does a summons trial conclude? What about the final verdict?
Section 278 covers the conclusion. After considering all the evidence presented, the magistrate records an order of acquittal if you're found not guilty. If found guilty, the magistrate, again, after hearing you on the question of sentence, passes sentence according to law.
Is there flexibility in the finding of guilt?
Yes. What's particularly flexible here is subsection 3. It allows a magistrate to convict you of any summons case offense that the facts admitted or proven during the trial appear to show you committed, regardless of what the initial complaint or summons alleged, provided, crucially, that you wouldn't be prejudiced by such a conviction.
So it avoids acquittals based on technicalities.
Exactly. It avoids technical acquittals just because the initial label for the offense was slightly wrong, ensuring that justice is served based on the proven facts rather than minor legal missteps in the complaint, as long as you had fair notice of the facts being alleged.
Okay. What about the complainant issue again? What if the person who filed the private complaint in a summons case just doesn't show up for the hearing? Can the case just linger?
Not anymore. Similar to warrant cases, Section 279 has that crucial new safeguard. If the complainant is absent on a day fixed for hearing in a summons case instituted on a complaint, the magistrate shall acquit you.
Shall acquit automatically.
Well, after first giving the complainant 30 days time to appear, so there's a grace period. But if they don't appear within that month, acquittal is mandatory, unless the magistrate, for some recorded reason, thinks it proper to adjourn the hearing. This ensures diligence from complainants and prevents cases from hanging over your head indefinitely due to their non-appearance. Of course, if the complainant is represented by an advocate or their personal attendance isn't needed, the case can proceed. The same principle applies if the complainant has died, the case doesn't just stall.
Makes sense. Can a complainant just decide to drop the charges in a summons case? Maybe they've reconciled or just don't want to proceed?
Yes, Section 280 allows for this. In summons cases, a complainant can seek to withdraw their complaint at any time before a final order is passed. They need to satisfy the magistrate that there are sufficient grounds for withdrawal, and the magistrate must grant permission.
And the effect of withdrawal?
It results in an acquittal for you, the accused, against whom the complaint is withdrawn. This provision is often used to facilitate amicable settlements between parties, promoting restorative justice where appropriate, especially in less serious disputes, and offering a practical way to conclude matters without prolonged litigation.
And can a magistrate just decide to stop a summons case trial midway if it seems pointless or maybe trivial, even if the complainant is still pursuing it?
What's fascinating here under Section 281 is the magistrate's power to do just that, particularly for summons cases not initiated by a private complaint, so typically those initiated by public officials. A magistrate of the first class or any other judicial magistrate with prior sanction from the chief judicial magistrate can stop the proceedings at any stage without pronouncing a final judgment, provided they record their reasons for doing so.
And what's the legal effect of stopping the proceedings? Is it an acquittal?
It depends. The effect hinges on whether the evidence of the principal witnesses has already been recorded. If it hasn't recorded, stopping the proceedings operates as an acquittal. If it has not, it operates as a release, which has the effect of a discharge. This provides an important escape valve for cases that, during the trial, appear futile, perhaps overly trivial, or where continuing would be a waste of judicial resources, balancing justice with practical administration.
One last thing on summons cases. Can a simple summons case, intended for minor offenses, ever turn into a more serious warrant case if things escalate or new facts emerge?
Yes, and this is a crucial flexibility provided by Section 282. If a case is being tried as a summons case, but it involves an offense punishable with imprisonment for a term exceeding 6 months.
Okay, more than 6 months potential jail time.
Right. And if it appears to the magistrate during the trial that, in the interests of justice, the case really ought to be tried according to the more detailed procedure for a warrant case, then they can convert the trial. They can proceed to rehear the case following the warrant case procedure laid down in Chapter XX. They can even recall any witnesses who may have already been examined under the summons procedure to examine them again under the warrant procedure rules. This crucial flexibility ensures that if a seemingly minor case reveals greater complexity or gravity during the proceedings, justice isn't compromised by using a procedure that's too simplistic. The appropriate level of procedural scrutiny can be applied, safeguarding fairness.
Okay, we've covered sessions, warrant, and summons cases. Finally, let's talk about what sounds like the absolute fastest way to get through the courts for really minor infractions: summary trials. What exactly are these, and who gets this express treatment?
Summary trials, outlined in Chapter 22, are indeed the express lane. They are designed for the most expeditious disposal of certain less serious criminal cases. What's fascinating here is how the BNSS not only grants magistrates the power to try cases summarily, but in some instances actually mandates it for specific offenses. It's all aimed at achieving swift justice for you in relatively minor matters, recognizing that not every infraction requires an elaborate, time-consuming procedure. It's about fitting the process intensity to the problem's severity.
So who can conduct these summary trials, and which offenses must be tried this way?
Any Chief Judicial Magistrate, CJM, or any magistrate of the first class, JMFC, specifically empowered by the High Court can conduct summary trials. Now, for certain listed offenses, these magistrates shall try them summarily under Section 283. It's not optional. It reflects the legislature's clear intent for speed in these specific areas.
What kinds of offenses are on this mandatory list?
Primarily petty property offenses. Think theft under specific BNS sections like 3032, 305, 306, receiving or retaining stolen property under 317.2, or assisting in concealing stolen property 317.5, but only where the value of the property involved does not exceed 20,000 rupees.
So there's a monetary limit for theft. That's key.
Absolutely. That 20,000 rupee threshold is crucial for defining petty in this context. Also on the mandatory list are certain specific subsections related to house trespass or house breaking, sections 3312 and 3 BNS, minor public order offenses like insulting someone to provoke a breach of peace, section 352 BNS, and certain types of criminal intimidation, sections 351, 2, and 3 BNS. Abetment or attempts of any of these offenses are also included, as are offenses under the Old Cattle Trespass Act, 1871.
So using your earlier example, if someone is accused of stealing a bicycle valued at, say, 15,000 rupees.
A JMSC shall try that case summarily, ensuring a quick resolution because it falls under the mandatory category due to the nature of the offense and the value being below 20,000 rupees.
Okay, that covers the mandatory summary trials. But can magistrates choose to conduct summary trials for other types of offenses beyond this specific list?
Yes, they can. Beyond this mandatory list, these empowered magistrates, CJM or JMFC, may also choose to try summarily any other offense which is not punishable with death, imprisonment for life, or imprisonment for a term exceeding 3 years.
That sounds like a much broader category. Are there safeguards?
Yes, this discretionary power comes with vital safeguards. First, you, the accused, must be given a reasonable opportunity of being heard on the question of whether the case should be tried summarily or not. Your view matters. Second, the magistrate must record specific reasons in writing for choosing to adopt the summary trial procedure in such a discretionary case.
And can you appeal the decision to try it summarily?
Crucially, no. There is no appeal specifically against the magistrate's decision to try a case summarily under this discretionary power. This emphasizes the finality of that procedural choice, aiming for speed.
But what if, during a summary trial, it becomes clear the case is actually more complex or serious than it first appeared? Is there an escape route?
Yes, absolutely. And this is a vital safeguard, a safety valve built into Section 283.3. If, at any point during a summary trial, it appears to the magistrate that the case is one which is of a character that makes it undesirable to be tried summarily, maybe complex evidence emerges, or the gravity seems higher than initially thought,
Yeah.
the magistrate shall recall any witnesses who may have already been examined under the summary procedure and proceed to rehear the case in the manner provided by the BNSS for a regular summons or warrant case, depending on the offense. This ensures fairness isn't sacrificed purely for the sake of speed if the case genuinely warrants a more detailed procedure.
So using your example, if someone's accused of an assault punishable with 2 years imprisonment, the JMFC might try it summarily after hearing the accused.
Right.
But if complex medical evidence suddenly comes up, making it more complicated.
They can and should switch back to a regular warrant case trial procedure.
Okay. Are there even simpler summary trials, perhaps handled by more junior magistrates for the absolute most minor infractions?
Yes. Section 284 allows for further delegation. The High Court can empower a judicial magistrate of the second class, JMSC, to conduct summary trials. But for them, the scope is even more restricted, reflecting their more limited sentencing powers.
How restricted?
A JMSC empowered for summary trials can only handle offenses punishable only with a fine or with imprisonment for a term not exceeding 6 months or without a fine, and any abetment or attempt of such offenses. This aligns with the BNSS's overall goal of dedicating appropriate judicial resources to different levels of offense severity, ensuring the very fastest procedures are strictly reserved for the least serious matters handled by the most junior magistrates. Hashtag tag outro.
Wow. Okay, what a journey that was. Through the real procedural backbone of India's criminal justice system under the new BNSS.
It's quite intricate, isn't it?
Absolutely. From the precise wording needed in a charge to the detailed rules governing these different types of trials, whether it's the high-stakes sessions court or the various procedures before magistrates in warrant, summons, or even those super-fast summary cases. Yeah. It's clear the BNSS aims for a system that's both meticulously detailed and hopefully dynamic. We've seen how pretty much every step, every section we discussed is designed, at least in theory, to ensure that you, as an individual facing the justice system, receive a fair and efficient hearing, whether the accusation is relatively minor or involves the most serious of charges.
And if we connect all this back to the bigger picture, these provisions, these chapters, they're far more than just dry legal text, aren't they? They are the gears and levers of justice in action. They attempt to carefully balance that critical need for efficient judicial administration getting cases resolved with the fundamental rights of the accused. The emphasis we saw on clarity in charges, the multiple opportunities for early discharge if a case lacks merit, the robust safeguards during charge alteration, and these tailored procedures for different types and gravities of cases. It all reflects a deep and hopefully evolving commitment to due process.
That's well put.
But, this also raises an important question, perhaps for you, the listener, to consider going forward. As these new provisions of the BNSS are actually tested and interpreted in the crucible of real-world legal battles playing out in courts across the nation, what new challenges might judges, lawyers, and citizens face in applying them? And looking ahead, what further innovations or adaptations might we see emerge in response to those challenges?
Indeed. It's a system constantly evolving, isn't it? Always adapting, hopefully, to ensure justice is not just served, but truly seen to be served. Thank you so much for joining us on this really deep dive into the BNSS procedural framework. Keep questioning, keep learning, feel like
and definitely
the
stay
legal
well
system is
informed
just
about
this
the laws that shape our
giant,
society.
bewildering maze.
Oh, absolutely.
You're trying to figure out how justice actually works. Maybe you even need to navigate it yourself, and bam, you're hit with all this legal jargon, these procedures. It just feels designed to confuse.
It's a very common feeling, that sense of being completely lost.
Yeah.
And that's exactly why clarity, understanding the how-to of justice really makes all the difference.
Right.
In a world just awash with information, having that clear roadmap, even for complex legal stuff, it can really ease that uncertainty.
Well, that's pretty much our mission today. We're doing a deep dive into some really fundamental procedural parts of India's new criminal code, the Bhartiya Nagrik Suraksha Sanhita 2023. We'll probably just call it the BNSS.
Good idea.
We're looking at things like how trials get sped up, how certain deals or agreements can be reached, the very specific rules for getting people who are already confined into court, and maybe most importantly, how evidence actually gets gathered and recorded.
Our goal here is really to pull out the crucial bits, the important nuggets, to sort of demystify these pretty intricate legal mechanics and hopefully give you that aha moment.
Exactly.
We've got the BNSS sections right here, our source material, and we're just going to guide you through what really matters in these parts.
Specifically, we're focusing on the chapters covering summary trials, plea bargaining, the attendance of persons confined in prisons, and some key bits from the big chapter on evidence and inquiries and trials.
Right. And each of these areas, they offer really unique insights into how the system is pushing for efficiency, but also trying hard to maintain those essential safeguards.
The foundations of fair and fast justice. Summary trials.
Okay, let's jump right in then. Summary trials. The name itself sounds fast, right?
It does.
But what does that actually mean for someone, facing charges? How does this quicker process really work under the new code?
It's an interesting balancing act, really. This first part we're looking at, Chapter 22, it lays down the basic rules for these faster trials.
Huh.
And maybe the most crucial thing to take away, it puts a hard, absolute limit on the maximum jail time you can get.
A hard limit. Okay. So on one side, you've got speed. The procedure for these summary trials, it generally follows the rules for what are called summons cases.
Right. Typically, less serious offenses.
Yeah, less serious stuff. It's much less elaborate than a warrant case trial, which is for the more serious crimes and involves, formal written charges and all that.
Exactly. So this streamlining, it's clearly designed to get minor disputes resolved quickly.
So you're bypassing a lot of the detailed steps you'd see in a more complex trial. The core accusation still has to be clear, obviously.
Oh, absolutely. The substance of the accusation must be stated. But the process is definitely leaner.
Right.
And then, like you said, there's that critical safeguard. The law explicitly states, for any conviction under this chapter, the maximum imprisonment cannot be more than 3 months.
Wow, 3 months. That
Yeah.
cap feels pretty significant, doesn't it?
It really is.
It means even if, say, a regular trial for the same offense might normally carry, I don't know, a year in prison, if it ends up being handled as a summary trial, maybe because the magistrate decides it's appropriate, that person is guaranteed they won't get more than 3 months. It just drastically cuts down the potential sentence.
And what's really insightful here, I think, is how that 3-month cap fundamentally shifts the strategic thinking.
How so?
Well, for the accused, it turns what could be a long, drawn-out ordeal into something more manageable, more time-bound. It often gives an incentive for a quicker resolution.
Okay.
And for the justice system itself, it acts as a critical pressure valve.
Yeah.
It stops minor cases from clogging up court time and resources that are really needed for more complex matters.
So what does this all mean for you, our listener? If you or someone you know gets caught up in a minor legal issue that goes to a summary trial, you get the benefit of a faster resolution, plus that guaranteed ceiling on potential jail time.
Right. It's designed, really, to reduce the anxiety about super long proceedings and punishments that might feel out of proportion for minor offenses.
And this isn't a totally brand new idea, is it?
No, not at all. Similar ideas existed in the previous criminal code, the CRPC. And court decisions over the years have consistently backed the idea that the intention here is swift disposal of less serious cases.
Right.
Implicitly acknowledging how important both efficient procedure and these kinds of sentencing limits are.
Which brings us to that key tension, I guess.
Exactly. How do courts consistently balance this undeniable need for speed and efficiency with, the fundamental right everyone has to a fair hearing, even if the potential sentence is relatively short?
That 3-month cap feels like a very direct legislative attempt to answer that.
It does.
Okay, so speed is one thing, but how does the court keep track of everything in these fast-paced summary trials? I mean, even quick decisions need some kind of record, right? You can't just wing it.
Absolutely not. And one of the fascinating things about the new code, the BNSS, is how much it insists on a clear record, no matter how quick the trial. Accountability is still paramount.
Right.
So even in a summary trial, the magistrate must, it's not optional, meticulously record specific details, specific particulars.
So it's not just jotting down guilty or not guilty. The law actually requires a mandatory entry, and the magistrate has to follow a specific form, one laid out by the state government.
Precisely. It's not an optional step at all. And the particulars they have to record are surprisingly comprehensive for what's supposed to be a summary proceeding.
Like what?
Well, everything from the case's serial number, the date of the offense, date the complaint was filed, names of the complainant, the accused, right down to the specific offense that was alleged, and crucially, the offense that was actually proven.
Okay.
And for certain types of cases, like some theft cases, even the value of the property involved needs to be noted down.
And it doesn't stop there, does it? It goes on to include the accused's plea guilty or not guilty, any examination they went through, the court's final finding, the sentence or the final order, and the exact date the case wrapped up.
That's quite a paper trail, even for a summary trial.
It really is.
Let's imagine Magistrate X is handling a case of petty theft. Maybe an item worth, say, 500 rupees.
Okay.
The record wouldn't just be a simple guilty. No, it would meticulously detail the case number, the dates, the accused Y's full name, parentage, the specific theft charge under the new BNS code, the item's value,
The plea.
Y's not guilty plea, a summary of the evidence that was presented, the court's guilty finding, the exact sentence, maybe a fine, maybe 7 days in custody,
Yeah.
and the precise date the case terminated.
Wow.
This level of detail, even though it's brief compared to a full trial record, it ensures transparency.
So what does this mean for you? If you're involved, it means there's a verifiable account, a clear paper trail you can refer back to. And for anyone just observing the justice system, it shows those fundamental elements of due process in action. It helps prevent arbitrary decisions and sets up at least a minimal basis for any later review.
And this commitment to a detailed record, even for these faster cases, it really underscores how important that record is for the validity of the decision and for any review.
Yeah.
Which makes you ask, how does this minimum record still allow higher courts to properly review decisions, especially when individual liberty is potentially at stake, even in these supposedly minor cases?
The integrity of that documented trail seems absolutely crucial for the whole system.
It really is.
Okay, it's good to know there's a record. But what if you plead not guilty in a summary trial? Does the court still have to explain why it reached its decision, or is it just a quick verdict?
That's a really vital point, and the new code, the BNSS, is very clear on this. Even in a fast-track summary trial, if the accused maintains their innocence, the court must provide reasons for its judgment.
No guesswork allowed.
No guesswork. So this part of the law, Chapter 22,
Right.
again, it specifically lays out the essential components of the judgment only when the accused hasn't pleaded guilty.
Right, because that's where the actual legal contest happens.
Exactly. In that scenario, the magistrate can't just state the verdict. They have a clear duty to record the substance of the evidence presented.
Meaning the key parts that swayed their decision?
The essential parts, yes.
Uh-huh.
The bits that influence the decision. And then they have to deliver a judgment that includes a brief statement of reasons for their finding.
Okay.
It's a crucial step to make sure the decision isn't just arbitrary.
Let's picture Z facing a summary trial for, say, simple hurt. Z pleads not guilty. After hearing from witnesses on both sides, the magistrate's judgment wouldn't just say guilty. It would need to summarize the key points from the testimonies, capture the substance, and then briefly explain why. Like, based on consistent prosecution testimony that wasn't rebutted, the court finds Z guilty.
That concise explanation, that's the brief reasons part, and it's fundamental to natural justice. For you, as the accused, it means a conviction or acquittal isn't just some pronouncement from on high. It's a reasoned decision, however concise. You get to understand why the court reached its conclusion.
Which is critical for procedural fairness, for trust in the system.
Absolutely.
Mhm.
And this principle, it echoes similar rules from the old code. Courts have always emphasized that a judgment without reasons, even in a summary trial, suggests a lack of proper thought, a lack of application of mind.
It really makes you wonder, though, how brief can those reasons be before they actually start to undermine the transparency and justice they're supposed to uphold?
It's a very fine line, isn't it?
It seems like it.
Okay, finally, for this chapter on summary trials, let's touch on the practicalities, language, administrative support. Even these details are meticulously covered in the new code to make sure the system actually functions smoothly.
Right, because the mechanics matter. So this section outlines language requirements for the records and judgments, and it allows for help in preparing them, but under specific rules.
Exactly. It's about clarity and efficiency in the background processes. A key point is that the language used for all records and judgments must be the official language of the court.
Okay.
This ensures consistency, makes records understandable for everyone involved, parties, lawyers, the public, higher courts reviewing the case. And it's the state government that determines this official language for its courts.
And you mentioned administrative help.
Yes, there's a practical provision for that. High courts can authorize magistrates to use an officer usually appointed by the chief judicial magistrate to help prepare these records or judgments.
That sounds like a sensible solution for busy courts, just helps with the workload.
It is. It's a pragmatic administrative measure. But, and this is important, while it provides help, the ultimate judicial responsibility always stays with the magistrate.
They still have to own it.
They have to personally sign the document. That signature authenticates its accuracy and confirms it's their decision, their approval.
So imagine a court in a region where, say, Marathi is the official language. All the summary trial records, the judgments, they have to be in Marathi.
Right.
Now, to help with the volume, the chief judicial magistrate might appoint a clerk to type up the record as the magistrate dictates it. But crucially, the magistrate must still sign that typed document, personally vouching for its accuracy and confirming it reflects their judgment.
So what's the takeaway for you here? It means transparency and accessibility. Justice isn't just the outcome, it's also understanding the process in a language you get.
Right.
And that administrative efficiency piece means cases hopefully don't get stuck just because of paperwork, allowing for a smoother, faster process overall.
This seems to follow similar ideas from the old code, too, underlining that even administrative details are vital for the record's authenticity.
Absolutely. Which leads to a lingering question. How do we make sure that this administrative support, while great for efficiency, never, ever compromises the integrity of the decision or the individual judicial thought process that needs to go into every single case?
A new path to resolution: plea bargaining.
Okay, let's shift gears and unpack this next big one, plea bargaining.
This concept has, well, it's really reshaped how certain criminal cases get resolved, hasn't it?
It certainly has.
Offering a potentially faster route to justice for many. But it's definitely not a free-for-all, is it? There are rules.
Absolutely not. And what's fascinating here is how the new code, the BNSS, in Chapter 23, has very carefully sculpted this mechanism. It's designed to be both efficient and equitable, but with really clear boundaries and safeguards.
It's like a structured way to manage the system's load, but under strict controls.
That's a good way to put it.
So to understand it, we need to know who can actually make a plea bargain. This gets us into the scope and, maybe more importantly, the crucial exclusions. What kinds of cases are even eligible?
Right. So it applies to accused people facing charges that come either from a police report or a private complaint. But here's the big limitation. It's only for offenses that are not punishable with death, life imprisonment, or imprisonment for more than 7 years.
7 years. That's the threshold. That's the key threshold. It's fundamental. It ensures plea bargaining is kept for, let's say, less heinous offenses. You're not bargaining away the most serious crimes.
That makes sense. And the code specifically carves out some major exclusions too, doesn't it? It doesn't apply to offenses that affect the socioeconomic condition of the country.
Correct.
Or crimes committed against a woman, or crimes committed against a child.
Yes, those are significant policy choices reflected right there in the law. These exclusions show a strong decision to treat crimes with broader societal impact or those involving vulnerable victims with the utmost seriousness. They demand a full trial, not a negotiated settlement.
And to avoid confusion about what counts as socioeconomic, the central government is supposed to issue notifications.
Exactly. They shall notify which offenses fall into that category. This provides clarity, prevents arbitrary decisions, and promotes consistency across the country.
Okay, let's make this concrete. If someone's charged with simple theft, say max 5 years prison under the BNS,
Yeah.
they'd generally be eligible for plea bargaining, right?
Generally, yes, assuming no other disqualifying factors.
But contrast that with someone charged with a very serious offense, like rape.
Not eligible. That's explicitly an offense against a woman, falling squarely into those exclusions.
Or maybe someone accused of a huge financial scam that the government has specifically notified as a socioeconomic offense.
Also not eligible.
Okay. So what does this mean for you? If you're an accused person, these clear rules tell you right away if plea bargaining is even an option for your specific charge.
Right.
And for society as a whole, it gives confidence that serious crimes aren't just being swept under the rug through negotiation. It maintains public trust.
And these provisions, they align with how courts viewed similar concepts before. The emphasis is always that plea bargaining must serve justice, not create an impression of, compromising on serious matters.
Yeah.
Which raises an important ongoing question. How do we continuously evaluate and refine these exclusions? Do they accurately reflect evolving societal values and justice priorities, especially as new types of crime or vulnerabilities emerge?
Okay, so let's say you are eligible for plea bargaining. How do you actually start the process? And maybe even more critical, how does the system make sure you're not being pressured into a deal you don't really want?
Yes. This brings us to voluntariness. It is the absolute bedrock, the foundation of the entire plea bargaining process. This section of the Code, Chapter 23, it lays out the precise steps an accused must take and fundamentally emphasizes that it must be a voluntary, informed choice.
Okay, so the accused has to file an application in the trial court. Is there a specific time window for that?
Yes, there is. The application has to be filed within 30 days from the date the charge against them is framed. It's a fairly tight deadline.
30 days. Okay.
Yeah.
And the application itself, it's not just a simple note.
No, it needs to be quite specific. It has to include a brief description of the case and, very importantly, an affidavit sworn by the accused themselves.
An affidavit, what does that need to say?
It has to explicitly state 3 key things. 1, the application is entirely voluntary. 2, the accused fully understands the nature and the extent of the punishment for the offense. And 3, the accused has not previously been convicted for the same specific offense.
That same offense bar again. So it stops repeat offenders for the exact same crime from constantly using plea bargains.
Precisely. It prevents habitual offenders of a specific crime from gaming the system.
Okay, so the application with the affidavit is filed. What's the court's next move?
The court issues a notice to the public prosecutor, or the complainant in a private case, and the accused, setting a date. But then comes the most critical safeguard, an in-camera examination.
In camera, meaning private.
Yes, private. The court examines the accused alone, without the other parties present, specifically to verify that their application for plea bargaining is genuinely voluntary, that they haven't been coerced or unduly influenced.
That private chat with the judge sounds like a really crucial protection for the accused.
It absolutely is. If the court is satisfied it is voluntary, it then gives the parties a set amount of time, up to 60 days, to try and work out what's called a mutually satisfactory disposition, or MSD.
Okay.
And this MSD may even include victim compensation, which is a nod towards restorative justice. The court then sets a date for a further hearing.
But what if the judge isn't convinced it's voluntary? Or finds out about that prior conviction for the same offense?
Then the application is rejected flat out, and the trial simply picks up from where it left off when the application was filed. Crucially, this happens without any prejudice to the accused.
Okay, let's visualize this. Accused A, facing an eligible charge, files the application within that 30-day window. A's affidavit clearly states, voluntary, understand the punishment, no prior conviction for this specific offense.
Right.
The judge then takes A aside, speaks to them privately in camera, confirms A isn't being forced. If satisfied, the judge says, okay, you and the public prosecutor have, say, 45 days to discuss terms. And those terms might include A, compensating the victim.
Exactly. So what does this mean for you? The whole process is meticulously built to protect the accused. That in-camera examination is your ultimate shield against coercion, making sure the choice is truly yours.
And the chance for victim compensation adds that restorative justice angle.
It does. It reflects how important courts consider genuine voluntariness and the accused fully understanding the deal, which again makes us ask, how can we ensure voluntariness is deeply understood not just by courts, but by everyone involved, including legal aid lawyers, to truly empower the accused in this process?
Right, so the application's in, the court's happy, it's voluntary. What next? Do the parties just, go off and haggle somewhere?
Oh, no, not at all. The court actually retains a really crucial role here as an impartial facilitator.
Okay.
And this is key. It makes sure the process stays structured, stays fair, even when they're trying to strike what is essentially a bargain. The new code is quite clear on how the court guides this negotiation.
So the court actually facilitates a meeting, brings the relevant people together to reach that mutually satisfactory disposition, the MSD.
Precisely. The code specifies who needs to be there. If the case started from a police report, you need the public prosecutor, the investigating police officer, the accused with their lawyer, and very importantly, the victim.
The victim is present, okay.
And if it's a case based on a private complaint, it's the accused with their lawyer and the victim.
So the court isn't dictating the terms of the deal.
No.
But acting more like an overseer, ensuring fairness. The law actually says it's the court's duty to make sure the whole MSD process is completed voluntarily by everyone involved.
That's the critical difference. The court facilitates, it doesn't participate in the actual negotiation itself. Its oversight is vital to prevent coercion or maybe misleading information being exchanged.
Yeah.
And having the victim there, as we mentioned, that's particularly noteworthy. It pushes towards a more restorative justice outcome, ensuring their voice is heard and their interests are considered directly.
Okay, back to accused A. Their voluntary application is accepted. The court calls a meeting. Since it's a police case, You'd have the public prosecutor, the investigating officer, A with A's lawyer, and the victim, V, who might also bring their own lawyer.
Right.
And they discuss terms. Maybe A pleads to a lesser charge, agrees to a specific sentence, and definitely agrees on compensation for V. The judge watches over this, ensures it's fair and voluntary, but doesn't impose the terms.
Exactly. So what does this mean for you? If you're a victim, this gives you a direct way to have your voice heard and potentially get compensation included as part of the resolution.
Right.
If you're the accused, it provides a structured, fair environment for a real negotiation, not just some arbitrary decision forced on you.
It echoes what the courts have said about needing voluntariness and the court playing that active, impartial role.
It does, which raises another important point. How do we really empower victims to fully participate? Make sure their interests are genuinely represented and considered so their presence isn't just, a box-ticking exercise.
Good question. So after all these discussions, what's the formal outcome? Is it just a handshake or is it more official?
It has to be official. This part of the new code formalizes the result of those MSD meetings. If they reach an agreement, it requires a signed report. If they don't, it's back to a regular trial.
Okay, so if an MSD is worked out successfully, the court prepares a formal report detailing that agreement. And this report needs signatures from everyone involved. The judge, the prosecutor or complainant, the victim, the accused, their lawyers.
Yes, that comprehensive signing is vital. It shows everyone agrees, ensures accountability, and gives the resolution real legal weight.
But what if, after all the talk, they just can't agree? No MSD.
Then the court simply records that fact, makes an observation that no agreement was reached, and the trial just picks up exactly where it left off before the plea bargaining application was even filed.
Okay, let's use our example again. Accused A and victim V, along with the public prosecutor, agree. A pleads guilty to a lesser charge, gets 1 year, pays V 50,000 rupees compensation. The court drafts a formal report with all these terms. Then the judge signs it, A signs it, A's lawyer, the PP, V's lawyer, everyone signs. It becomes a formal, documented deal.
But if they couldn't agree on the term,
The judge just notes no agreement reached and sets the case down for a full trial, just as if plea bargaining had never happened.
Exactly. So what's the bottom line for you? Transparency and accountability. A formal signed report gives legitimacy to the deal.
Yeah.
And crucially, if the bargain falls through, you, as the accused, aren't penalized. Your case just continues. That's a vital protection.
That ability to revert to trial without prejudice seems like a really important safety net. It encourages people to explore plea bargaining without fearing they'll be worse off if it doesn't work out.
It does. Which brings up another thought. How do we ensure the terms agreed upon aren't just mutually satisfactory, but also truly uphold broader principles of justice and the public interest? It's a delicate balance. Right, so once that mutually satisfactory disposition is finalized and signed off, the next step is sentencing. But, as you hinted, this isn't just a standard sentence calculation.
No.
What's really fascinating here is the specific structured leniency that's explicitly built into the BNSS for cases resolved through plea bargaining.
Structured leniency.
Okay.
So the code details exactly how the court handles sentencing after an MSD. It prioritizes victim compensation first.
Yes, absolutely. First and foremost, the court must award compensation to the victim as agreed in the MSD. This really highlights that restorative justice aspect.
Okay.
After that, the court hears arguments from both sides on the actual sentence quantum, and it considers options like probation, admonition, or applying the Probation of Offenders Act.
And then we get to these specific sentencing reductions you mentioned, the structured leniency part.
Exactly. For cases where the law prescribes a minimum punishment,
Like, say, a mandatory minimum of 2 years.
right. In those cases, the court may sentence the accused to half of that minimum.
Half.
But wait, there's more. If the accused is a first-time offender, the court can reduce it even further, potentially sentencing them to just 1/4 of that minimum punishment.
Wow, 1/4 of the minimum for a first-timer. That's significant. What about cases without a minimum sentence?
For other eligible cases, those without a prescribed minimum or ones not covered by probation laws, the court may sentence the accused to 1/4 of the maximum punishment provided for the offense.
Okay, 1/4 of the max.
And again, that extra benefit for first-time offenders, they might be sentenced to just 1/6 of the maximum punishment.
1/6.
These precise fractions, half, quarter, sixth, they provide a very powerful, very clear incentive for plea bargaining, especially for first-time offenders. And they give clear guidance to judges, which helps promote consistency.
Let's run that scenario again. MSD reached. A pleads guilty. Offense has a minimum of 2 years, max of 5. A is a first-time offender.
Okay.
First, victim compensation is awarded. Then, under the code, the court may sentence A to 1/4 of the minimum, so just 6 months.
Potentially, yes. 6 months instead of the mandatory minimum 2 years.
Now, what if the offense had no minimum, but a maximum of 4 years? A is still a first-time offender.
In that case, A might get 1/6 of the 4 years, which works out to about 8 months under that other clause.
These are really tangible benefits.
They absolutely are. So what does this mean for you? It offers a substantial, concrete advantage for cooperation, especially if you're a first-time offender. It can dramatically cut potential prison time, offering a much clearer path forward and faster closure.
It seems like it aligns with a more reformative approach to sentencing in these specific cases.
It does. Courts are expected to follow these statutory formulas strictly. Which does raise an important practical question. Could this structured leniency unintentionally create an unfair advantage? Maybe favoring those who can afford better legal advice to navigate the plea bargaining process effectively, potentially leaving others behind.
That's a fair point. So once the sentence is decided via plea bargain, is that really truly the end of the line? No more appeals, no challenging it later.
That's essentially the goal. The whole point of a plea bargain from a system's perspective is certainty and finality, to resolve cases definitively and efficiently. This part of the code really cements that.
Okay, so the judgment has to formally reflect the plea bargain terms, be delivered publicly in open court, signed by the judge, standard procedure for transparency.
Right, and then comes the critical part. Once that judgment is made, the new code declares it final. And here's the key phrase. No appeal shall lie in any other court against such a judgment.
No appeal. That's a very strict bar.
It is. It's designed specifically to reinforce the certainty aspect of the bargain. But it's not an absolute hermetic seal. It doesn't affect your constitutional right to file a special leave petition, SLP, to the Supreme Court.
Under Article 136.
Correct. Or a writ petition to the High Court under Articles 226 and 227.
So those fundamental constitutional remedies remain available, but only for really extraordinary situations, like gross injustice, fundamental rights violations, not just for trying to renegotiate the deal you already agreed to.
Exactly. It's not a back door to appeal the agreed terms.
Let's illustrate. Accused A gets sentenced to 6 months via plea bargain. Judge pronounces it, signs the judgment in open court. A cannot then file a standard appeal against that sentence or conviction.
Correct.
However, if A genuinely believes the entire plea bargaining process was fundamentally flawed, say, vitiated by serious fraud or coercion that the trial court completely missed, A could potentially seek review through a writ petition in the High Court or maybe even an SLP in the Supreme Court, arguing a violation of fundamental rights or process.
Yes, those constitutional avenues remain, but the bar is high. So what does this mean for you? It offers a definite end to the legal proceedings, bringing closure much faster. But it also underscores how crucial it is to be absolutely certain about your decision before agreeing to the plea bargain, because your options to challenge it later are extremely limited.
The legislative push for finality is clear.
Very clear. Constitutional interference is meant to be narrow for fundamental flaws only, not just second-guessing the bargain, which does make you ponder, how does a system prioritizing finality deal with those rare but critical instances where truly new, compelling evidence might surface after a plea bargain is completely finalized?
Now, during the plea bargaining process itself, are the court's hands tied in other ways? Does it lose its usual powers? What about time someone might have already spent in jail before the bargain?
Good questions. No, the court absolutely retains its full authority throughout the process. The code makes that clear. And yes, critically, any time already spent in pretrial detention must be credited against the final plea bargain sentence. This section also does something else important. It gives the plea bargaining chapter an overriding effect over any inconsistent parts of the new code, and it clarifies who counts as a public prosecutor for these purposes.
So the court still has all its normal powers regarding bail, handling other aspects of the trial, general case disposal. Plea bargaining is like a special track. But it doesn't diminish the court's overall control.
That's right. It ensures continuity and effectiveness. And on the fairness side, the code explicitly mandates that pretrial detention time must be set off against the plea bargain sentence. That's a vital fairness provision.
Giving credit for time served.
Exactly. Then there's this important overriding effect clause. If a general rule somewhere else in the BNSS conflicts with a specific rule in the plea bargaining chapter, the plea bargaining rule takes precedence.
Okay, so this chapter's rules win out in case of conflict.
Yes. And it also clarifies that for this chapter, the definition of public prosecutor includes assistant public prosecutors, or APTs.
Why is that significant?
It's practical. APPs often handle cases in magistrate courts. Including them here makes the plea bargaining process more accessible and efficient at the grassroots level, where many of these eligible cases are handled.
So putting it together,
Yeah.
while accused A is exploring plea bargaining, they can still apply for bail, and the court decides that bail application just like normal.
Correct. Plea bargaining doesn't suspend other rights.
And if A is sentenced to, say, 1 year through the bargain, but they already spent 3 months locked up as an under trial?
They only serve the remaining 9 months. The 3 months are automatically credited.
And if some general rule clashes with a plea bargaining rule, the plea bargaining rule prevails. Plus, an APP can officially represent the state in these negotiations.
Absolutely. So what's the key takeaway for you? You don't lose out on other legal rights, like applying for bail, just because you're exploring a plea bargain. And crucially, any time you've already served counts towards your sentence. It's about fairness.
That set-off for time served is a recognized right.
It is. And the overriding clauses are standard practice for special procedures to ensure they work as intended. Which leads to a practical thought. How does, specifically including APPs in the definition here, enhance the efficiency and accessibility of plea bargaining, particularly at that local magistrate court level?
Right. Now, this plea bargaining system sounds generally well-structured, but what if the deal falls through? Can anything said during those negotiations be used against the accused later if the case goes to trial?
A critical question.
And what about young offenders? Do they use this same adult plea bargaining system?
These are absolutely crucial protections, and the new code provides very clear boundaries here, ensuring fairness and upholding specialized justice principles for juveniles. It covers what happens if negotiations fail, and it explicitly excludes young offenders.
Okay, so the code protects the accused by stating that anything they say in a plea bargaining application cannot be used against them for any other purpose.
Yes, that's a vital safeguard. Any statements made, any facts disclosed within that plea bargaining application shall not be used for any other purpose except for the plea bargaining process itself. Chapter 23.
It creates a kind of safe zone.
Exactly. A safe zone for the accused to explore plea bargaining without the fear that admitting something during negotiations will come back to bite them if the deal doesn't happen and the case goes to a full trial. It avoids self-incrimination in that context.
And for young offenders, juveniles or children.
The code is explicit. They are completely excluded from this entire plea bargaining framework.
Okay.
It states clearly that nothing in this chapter applies to any juvenile or child as defined by the Juvenile Justice Act, 2015.
So it upholds the separate juvenile justice system.
Absolutely. It maintains that distinct philosophy, which is rehabilitative, child-centric, keeping it entirely separate from the adult criminal justice system's plea bargaining mechanism.
Still straight. Accused B makes certain admissions or statements in their plea bargaining application. If, for whatever reason, no MSD is reached and the case proceeds to trial, the prosecution is legally barred from using B's statements from that application as evidence against B in the trial.
Correct. And if a 16-year-old is accused of an offense, even one that, if committed by an adult, would be eligible for plea bargaining, they cannot use these Chapter 23 provisions. Their case must be handled under the Juvenile Justice Act.
Period. They fall under that specialized protective framework.
Unequivocally. So what's the bottom line for you? For adults, it's reassurance that exploring a plea bargain is a consequence-free option if it doesn't pan out. You're not penalized for trying. For juveniles, it means they are definitively under a specialized protective legal system, not the adult one.
That confidentiality of plea bargaining talks and the exclusion of juveniles seem like really important principles.
They are aligning with established legal thought and international child rights standards. Which poses a final thought for this section. How does maintaining this clear distinction between adult plea bargaining and the separate juvenile justice system effectively ensure both goals are met, swifter resolution for eligible adults, and upholding the paramount interest and specific needs of the child in juvenile cases?
Bringing the confined to court. Prison attendance rules.
Okay, let's tackle a really practical challenge the justice system faces all the time. What happens when someone is already locked up, maybe serving a sentence or awaiting trial for one case, but they're needed in court for a different matter, maybe as an accused in another case or even just as a witness?
Yeah.
It can't be as simple as just, opening the cell door and letting them walk over, can it?
Oh, absolutely not. It's far from simple. And this is an area where the new code, the BNSS, provides a very precise legal framework. It's meticulously balancing the court's genuine need for that individual's presence against really complex concerns, security, public order, the rights of the person who's confined.
Right.
This part of the code, Chapter 24, it actually starts by expanding the definitions of who counts as detained and what counts as a prison, and then it empowers criminal courts to summon these individuals.
Okay, so broadening the scoop first. Detained and prison get wider definitions just for these rules.
Exactly. Detained now explicitly includes people held under any law, even preventive detention laws, not just standard criminal custody.
Okay.
And prison is expanded beyond just traditional jails to cover a whole range of facilities, subsidiary jails, reformatories, borstal institutions for young offenders, things like that.
So these rules apply very broadly.
They do. It ensures the rules apply comprehensively, no matter the specific type of custody.
And then the courts get the explicit power to order these confined persons to be brought before them, whether it's to answer a new charge, participate in proceedings, or just give testimony.
That's right. During any inquiry, trial, or other proceeding, if a court decides it's necessary, it can issue an order directly to the officer in charge of the prison.
Telling them to produce the person.
Yes, either to answer a charge or for proceedings against them, or simply to be examined as a witness. But, and this is a vital check, there's an oversight mechanism, particularly for more junior judicial officers.
Okay.
An order issued by a magistrate of the second class requires a countersignature from their superior, the Chief Judicial Magistrate, CJM, before it's valid.
Ah, so the CJM has to approve it. It acts like a check.
Exactly. And to get that countersignature, the magistrate has to submit a statement justifying why the order is necessary. The CJM can actually review that justification and decline to countersign if they aren't convinced.
That seems like a sensible control, preventing potentially unnecessary movements, which obviously involve security risks and administrative hassle.
It is. It prevents unnecessary production orders.
So let's paint a picture. Someone held under a preventive detention law, maybe in a special facility, they're still considered detained under these rules. A criminal court can summon them.
Right. Or a young offender in a borstal institution, same rules apply, they can be summoned.
Or consider accused A, already serving a sentence in jail X, but needed in court Y for a completely new charge. The magistrate in court Y issues an order for A's production.
Okay.
Now, if that magistrate is a second-class magistrate, they need to get their CJM's countersignature on that order, backed by a statement explaining why A's presence is essential.
Precisely. So what does this mean for you? It confirms the justice system can function and bring people to court even if they're already confined. If you're a prisoner, it means your presence can be legally mandated, but there are important procedural checks, especially if the order comes from a lower-ranking judge.
It's about ensuring the accused's right to be present at their trial is upheld, even if they're already in prison.
While also acknowledging the real-world practicalities of security and administration. Which leads to a key question. How does this intricate system, with its checks and balances, effectively guarantee that fundamental right to be present without creating undue risks or administrative nightmares?
Okay, so courts have the power to summon prisoners, but can anyone else step in and just say, nope, this prisoner isn't leaving the jail? Can the government override the court?
Absolutely. And this is where it gets particularly nuanced. It really highlights that critical balancing act between judicial power and executive concerns, things like national security, public order.
Right.
And the prison officer themselves, they act almost like a gatekeeper in this situation, because the law gives them very specific legal grounds to refuse to comply with a court's production order.
So the state or even the central government can actually issue an order that overrides a court's summons, prohibiting a prisoner's removal. That sounds like a significant executive power.
It is an extraordinary power, yes. The government, state, or central can, by a formal order, direct that a specific person, or even a whole class of persons, shall not be removed from the prison where they're held. And that government order effectively nullifies any court order under Section 302 trying to summon them.
What factors would they consider?
The law says they must consider the nature of the offense the person is charged with, or the grounds for their confinement, the likelihood of a disturbance of public order if that person were removed and transported, and the general public interest.
So typically for high-risk situations.
Exactly. Think gang leaders whose appearance might spark violence, or individuals deemed serious security threats where transport itself is risky.
Okay. And the prison officer themselves also has specific, legally defined reasons where they must refuse to produce a prisoner even if there's a court order.
Yes, absolutely. An officer must abstain, they don't have a choice, from carrying out a court's production order in several clear situations.
Such as?
If the prisoner is medically unfit, serious sickness or infirmity, or if they are currently under committal for trial, or on a remand pending trial or investigation for another case.
Ah, so if they're tied up in another active proceeding.
Right, unless they are needed purely for giving evidence within a 25-kilometer radius of the prison. That's a specific exception.
Okay, 25 kilometers for witness testimony is allowed.
Yes. They must also abstain if the prisoner's current custody term is set to expire before the logistics of taking them to court and bringing them back can realistically be completed.
Makes sense.
And of course, if the prisoner is subject to one of those overriding government orders we just talked about under Section 303, in any of these refusal scenarios, the officer is legally required to send a written statement to the court explaining the reasons for abstaining.
Okay, let's try an illustration. High-profile terrorist in jail. Intelligence suggests moving them to court for a minor hearing could trigger an escape attempt or public chaos.
Right.
The central government might issue an order under Section 303 overriding any court summons for their physical presence. They might have to testify remotely, perhaps?
Exactly. Or, another scenario, court orders prisoner X to be produced. But the jail doctor provides a certificate saying X has severe pneumonia and is unfit to travel.
The jail superintendent must refuse.
Must abstain. They inform the court, citing the medical condition. Now, consider prisoner Y, who is under trial for a major murder case in City A. They're needed as a witness in a totally separate case in City B, which is 300 kilometers away.
Can the officer refuse?
Yes, the officer can abstain because Y is actively involved in another trial elsewhere. But if that court in City B was only 15 kilometers away, the officer could not use the ongoing trial reason alone because of that 25-kilometer exception for witnesses.
Wow, that's quite specific.
It is. So what's the takeaway? These sections clearly show a court summons isn't an absolute unbreakable command. There are critical, legally defined exceptions for health, for logistics, for ongoing proceedings, and even for overarching national security concerns. It really demonstrates a complex interplay of powers.
It's a balance between security and judicial access.
And while the government's power is recognized, courts have also stressed it shouldn't be arbitrary. They often scrutinize the reasons given for abstention, which raises that critical question again. How do we ensure this executive power to exclude a prisoner is always used transparently and judiciously, preventing any potential misuse to perhaps avoid accountability or obstruct justice?
Okay, so let's say a prisoner is allowed to come to court. How are they transported? Is it always a high-security convoy? And if they can't physically come, is there any other way for the court to get their testimony?
Right, it's that critical balance against security versus judicial access. What's insightful here is the dual focus. First, the strict emphasis on continuous, secure custody during transport, and second, the provision for remote examination as a practical alternative. It's about ensuring justice is installed.
So the code mandates that prisoners, when brought to court, must be securely transported, kept securely, and returned securely.
Precisely. Unless there's a valid reason for not producing them, like sickness, the prison officer's duty upon receiving a valid court order is crystal clear. They must arrange for the person to be taken to court at the specified time.
Okay.
And crucially, they must ensure the person is kept in custody, either in the court premises or nearby, until their examination is done or they're allowed to return. Continuous, secure custody is the watchword throughout the entire process.
And if physical production just isn't feasible, maybe due to health, security risks, or extreme distance, the code allows for commissions.
Yes. It explicitly clarifies that these rules about physical production do not limit the court's existing power to issue what's called a commission to examine a prisoner or witness.
What's a commission, exactly?
It's essentially a formal request, usually directed to another judicial officer, to go and record the witness's testimony remotely, wherever they are confined. The rules for how these commissions work are detailed elsewhere in the code.
So it's a vital alternative.
A crucial alternative, yes. If physical production is impractical, too risky, or just unnecessary, A commission ensures the evidence can still be collected and presented formally.
Let's illustrate. Prisoner Z is ordered to court. The jail superintendent arranges a police escort. Z is carefully transported, kept in a secure court lockup or under constant guard during the hearing, and then escorted back to jail, always in custody.
Right. Now, consider an elderly, seriously ill prisoner, P, vital witness, but moving them poses a severe health risk.
They can't come physically.
So instead of ordering physical production, the court issues a commission. It appoints a magistrate who then goes to the prison hospital and formally records P's testimony right there. The evidence is captured despite the challenge.
So what does this mean for you? If you're a prisoner being taken to court, you'll be under constant supervision that's for security and procedure. If you're a witness who happens to be in prison, your testimony can still be heard even if you can't physically appear in court, ensuring justice doesn't get stuck.
And courts have recognized that modern tools, like secure video conferencing, can be very effective alternatives for recording evidence remotely in these situations. Which makes you wonder, as technology keeps advancing, how might remote testimony options further revolutionize how confined individuals participate in legal proceedings? Could it strike an even better balance between security, efficiency, and accessibility?
The art of evidence. Recording and presenting in BNSS.
All right, let's dive into this really big chapter on evidence, Chapter XE5. This is often where cases are truly won or lost, right?
Absolutely. It's the cornerstone.
Yeah. How is evidence actually gathered, recorded meticulously, and then presented in court under the new BNSS? Is it always like a word-for-word transcript, or are there different ways of doing it?
It's a critical area, and you can see the level of detail the BNSS dedicates to it. It's trying to balance that need for meticulous, accurate recording with, practical efficiencies. It aims for fairness while adapting to different types of cases, different complexities. We start with some fundamentals. Language barriers and ensuring the accused is actually present.
Right. So first, the state government decides the official language for the courts in that state, but not the high court.
Correct. The state government sets the language for all criminal courts within its jurisdiction, except the High Court, which maintains its autonomy. This is vital for making justice accessible to the local population.
And then, crucially, the code generally insists that evidence must be taken in the presence of the accused.
Yes, that's the general rule. All evidence taken during a trial or other proceeding must be in the presence of the accused.
That sounds like a fundamental fair trial.
All right.
Confronting your accusers.
It absolutely is. Allows the accused to hear the evidence directly, observe the witness, instruct their lawyer. However, there are practical exceptions built in.
Okay.
If the accused's personal attendance has been dispensed with, maybe they're very ill, or perhaps their conduct in court is completely disruptive,
Right.
then the evidence can be taken in the presence of their advocate instead. And significantly, the new code explicitly allows this to happen using audio-video electronic means, so embracing modern tech.
Video conferencing, essentially.
Yes. And there's also a very important special proviso for child victims in sexual offense cases.
Okay.
The court can take specific measures to prevent the child from having to directly confront the accused face-to-face to reduce trauma. But crucially, this must be done while still ensuring the accused's fundamental right of cross-examination is fully protected.
Balancing protection with due process.
Exactly. It addresses trauma reduction, but includes essential safeguards for the accused.
Okay, let's imagine the Maharashtra state government declares Marathi as the official language for its lower courts. So evidence there gets recorded in Marathi.
Right. Now, in a typical theft trial, all the witnesses would testify with accused X physically present in the courtroom. But if X becomes seriously ill and the court excuses their physical attendance, X's lawyer can still fully participate, maybe via a secure video link, hearing the evidence and cross-examining witnesses remotely.
And for that child victim example, a 10-year-old girl in a sexual assault case.
The court might use, say, a screen in the courtroom or have the child testify from a separate room via video link to shield her from direct confrontation. But the accused lawyer, perhaps also participating remotely or from the main courtroom, still gets to fully cross-examine her, ensuring the accused's rights are met.
So what does this mean for you? You have that fundamental right to understand and challenge the evidence against you, whether you're there in person or through your lawyer, possibly via video. And vulnerable witnesses get crucial protection, but without sacrificing due process.
Indeed. And this modern approach, embracing virtual presence, aligns with court rulings that have accepted video conferencing, which does raise an important practical question. How do courts ensure these tech solutions truly uphold the spirit of presence? Does video always allow for effectively observing a witness's demeanor, those subtle nonverbal cues that can be so important for judging credibility?
Good point. So given these different scenarios, is the court always recording every single word, like a court reporter typing furiously? Or is there flexibility in how much detail gets captured?
That's a really important distinction. And what's insightful here is that the BNSS uses a graded approach to recording evidence.
Graded, meaning different levels of detail.
Exactly. It reflects the seriousness and complexity of the case. It aims for efficiency where possible, but demands accuracy and detail where it's really needed. It's about being pragmatic without sacrificing the substance of the testimony.
Okay, so for less serious cases, there's a simpler method, like for summons cases and maybe some inquiries.
Yes. For those, the magistrate makes a memorandum of the substance of the evidence, basically a summary of the key points in the court language, which they then sign.
Just the gist. Expedites things.
Right. Captures the essentials, not necessarily verbatim, but for more serious matters, the level of detail goes way up.
Like for warrant cases, the ones involving more serious offenses.
Correct. For warrant cases, the evidence has to be taken down in writing. This can be done by the magistrate themselves, or they can dictate it, or have a court officer type it under their direct supervision.
And you mentioned modernization here too.
Yes. Significantly, it may also be recorded using audio-video electronic means, especially if the advocate is present.
So a video recording of the testament.
Potentially, yes. And the format is usually a narrative summary. But the magistrate has the discretion to switch to a question and answer format for specific parts, especially during cross-examination where precision is critical. And again, it all gets signed by the magistrate.
Much more comprehensive for serious cases. Audio-video gives a more complete record. Q&A gives precision.
Exactly. And this same detailed method applies to sessions trials as well, those handling the most grave offenses. A meticulous written record, or audio-visual, usually narrative, but with discretion for Q&A, all authenticated by the presiding judge's signature.
Forming the crucial basis for potentially severe sentences and any appeals.
Absolutely. And then there are rules about the language of the record. If a witness testifies in the court's official language, it's recorded in that language. Simple enough.
But what if they speak a different language?
If practicable, the court can record it directly in that language. If that's not feasible, then a true translation into the court language is made, and that translation becomes the record.
And if it is recorded in another language?
A true translation into the court language must be prepared shortly thereafter and kept with the record. There's also a practical proviso. If evidence is given in English and none of the parties require a translation into the court language, the court can dispense with making that translation.
Balancing accuracy, accessibility, and practicality.
Precisely.
Okay, let's run through examples. Petty traffic violation. Summons case. Magistrate notes down the gist of the police officer's testimony. Memorandum of substance.
Correct.
Grievous hurt case. Warrant case. Magistrate writes down the witness's full account. A crucial cross-examination bit might be recorded verbatim, Q&A style. Maybe the whole thing is even video recorded.
Yes, much more detailed.
And language. Court language is Hindi. Witness speaks English. It can be recorded in English with the proviso about parties not needing translation. Witness speaks Tamil. An interpreter provides a Hindi translation, and that Hindi translation goes into the record.
Exactly. So what does this mean for you? The level of detail in the court record scales directly with the seriousness of the case. Proportionate attention. And the multilingual rules are there to ensure language barriers don't block justice.
This graded approach seems logical.
It aligns with historical legal principles. But it does make you think, how will the increasing use of audio-video recording change how higher courts review evidence? Will they rely more on the video, potentially getting a richer sense of the testimony, including those nonverbal cues?
Interesting thought. So the evidence is recorded with varying levels of detail. Is that the end of it? Or does someone get to check if it's actually accurate? Like, read it back.
Oh, yes, absolutely. That's a critical step. The new code builds in layers of verification and context. It ensures the written record faithfully reflects what was said, and it even allows judges to note those subtle things demeanor that words alone can't capture.
Okay, so this part mandates reading the completed deposition back to the witness for them to verify or correct it.
Exactly. Specifically for warrant cases and sessions trials, the more serious ones. The recorded evidence must be read over to the witness in the presence of the accused or their lawyer. Any necessary corrections are made right then and there.
What if the witness disagrees with the record? Says, "Hey, I didn't say that."
Good question. If the witness disputes the accuracy, maybe claims they said possibly, when the record says certainly, the magistrate or judge doesn't automatically have to change the original record. Instead, they can make a note of the witness's objection and add their own remarks about what they believe was actually said.
Ah, noting the dispute rather than altering history.
Right. And also, if the witness doesn't understand the language the record is written in, it must be interpreted to them. It's all about accuracy and fairness.
And similar interpretation rules apply to the accused or their advocate if they don't understand the language the evidence is given in.
Yes, fundamental to a fair trial. If evidence is given orally in a language the accused, who is present, doesn't understand, it must be interpreted to them right there in open court. Same for the advocate if they don't understand. For documents, the court has discretion to interpret key parts needed for formal proof.
And then there's that fascinating point about recording demeanor.
Yes. The judge or magistrate must record any material remarks about the demeanor of the witness while they're testifying.
Why is demeanor important?
Well, how a witness behaves, are they nervous, evasive, overly confident, straightforward, can offer vital clues about their credibility. These recorded observations help the judge evaluate the testimony, and they're especially useful for appellate courts who only have the written record later on.
Okay, let's see this in action. Witness W finishes testifying. Their recorded statement is read aloud. W says, actually the date was the 15th, not the 16th. The judge corrects it.
Simple correction.
Another witness, Y, listens and says, wait, I said maybe, but the record says definitely. The judge, recalling the testimony, makes a note. Witness objects states they said maybe. Court's recollection is witness stated definitely.
Noting the objection and the court's observation. Perfect.
And if an accused only understands Bengali, any English testimony must be interpreted live for them.
Right.
And the judge might make a note like, witness appeared hesitant and repeatedly avoided eye contact when questioned about financial records, providing context for assessing credibility later.
Exactly. So what does this mean for you? These are your checks and balances. You can ensure the record's accuracy, you're guaranteed to understand what's being said through interpretation if needed, and the court considers the human element, the demeanor, not just the words on paper.
These seem like vital parts of ensuring a fair process.
They are. Mandatory reading over, interpretation, noting demeanor, these are established principles, which raises another modern challenge. In courtrooms, increasingly using video, how do you effectively capture and convey those subtle nuances of demeanor to appellate courts reviewing the case later who lack that direct in-person observation?
Video might capture some things, but maybe not everything a live judge observes. Okay, what about the accused's own statement to the court when the judge questions them? How carefully is that recorded? And do higher courts, like the High Court, follow exactly the same strict rules for evidence?
Right. The accused statement under examination is a crucial part of the process. And what's striking here is the absolute rigor applied to recording that statement, which actually contrasts with the flexibility given to high courts in setting their own rules. It reflects their different functions.
Okay, so for the accused examination, the code demands a super detailed procedure, recording every question, every answer, plus verification.
Precisely. The standard is completeness. The whole of the examination, including every single question put to the accused and every single answer they give, must be recorded in full. This is typically done by the judge or magistrate directly or under their immediate direction.
Language.
If practical, it's recorded in the accused's own language. If not, then in the court's official language.
Done verification.
Yes, after it's recorded, it must be read over or shown to the accused or interpreted if needed. And critically, the accused gets the chance to explain or add to their answers at this stage.
A chance to clarify.
Exactly. Then it's signed by both the accused and the judge magistrate. And the judge magistrate adds a certification stating it's a full and true account of the examination. There's even a proviso for electronic examination signatures needed within 72 hours. But, important note, this super detailed procedure does not apply to summary trials.
Okay, so maximum care for the accused statement in regular trials. And if an interpreter is used during this?
The code explicitly states they are bound to state the true interpretation, a clear legal and ethical duty vital for accuracy.
And the High Court gets more leeway.
Yes. The BNSS grant high courts the power to prescribe the manner for recording evidence, both witnesses and accused in cases before them, through their own general rules. This recognizes their superior status and allows them flexibility to adapt procedures as they see fit for their own workings.
So picture this. After the prosecution finishes, the judge examines the accused. Every question, did you see X? And every answer, no, I was at home, is painstakingly recorded.
Word for word, essentially.
Then that record is read back to the accused or interpreted. They might say, wait, when I said at home, I meant my parents' home. That clarification gets added. Then they sign, the judge signs and certifies.
Perfect. And if an interpreter was translating the judge's questions into the accused language, that interpreter is legally bound to be accurate.
Right. Meanwhile, a high court hearing, an appeal, might have its own specific rules, perhaps using official stenographers for arguments or adopting different methods for recording evidence in its specific jurisdiction, potentially differing from the detailed lower court rules.
Exactly. So what's the takeaway? Your direct statement to the court during examination is treated with the highest level of scrutiny to ensure accuracy and fairness. Interpreter trustworthiness is legally mandated. And remember, how evidence gets recorded can change depending on which level of court you're in.
The accuracy of the accused's examination is clearly paramount.
It is. Which makes you think, how does the flexibility given to high courts potentially impact a standardized approach? Does it help tailor procedures effectively, or could it sometimes complicate consistency across the justice system?
What if a really key witness is, say, living abroad? Or maybe they're in India but too sick or frail to travel to court? Does the whole trial just grind to a halt?
Oh, no, not at all. And this is where the BNSS provides some really clever established solutions for getting evidence even when physical presence just isn't feasible. It ensures justice doesn't get stalled by these kinds of logistical hurdles. We're talking about commissions again, but specifically for witnesses.
Okay, so a court can issue a commission to examine a witness if getting them to court would cause unreasonable delay, expense, or inconvenience.
Right. Exactly. Or, interestingly, it's mandatory if the testimony is needed from very high constitutional functionaries like the president, vice president, a governor, or administrator. The court shall issue a commission in those cases if their evidence is necessary.
Mandatory for them.
Okay. And there's a fairness provision, too. If the prosecution wants to examine one of their witnesses on commission, the court can actually order the prosecution to pay the accused reasonable expenses for participating, including their lawyer's fees.
Ah, leveling the playing field somewhat if the accused has to participate remotely or send their lawyer.
Precisely. It balances efficiency, justice, and practicality.
And the code is specific about who these commissions are sent to, depending on where the witness is.
Yes, very clear channels. If the witness is within the BNSS territory, it goes to the Chief Judicial Magistrate, who can assign it to another magistrate. If they're elsewhere in India but outside BNSS jurisdiction, it goes to a court or officer notified by the central government. And if they're outside India, especially in a country with reciprocal arrangements.
Like the UK example earlier.
Exactly. It's sent in a specific form to the relevant court or authority there, following procedures prescribed by the central government. It facilitates that international cooperation.
And how does the magistrate receiving the commission actually execute it?
They either summon the witness to their court or, if necessary, they can go to the witness's location, like a hospital. Then they take the evidence using the same procedures and powers as they would in a warrant case. So, same level of detail and safeguards.
Ensuring quality control even when done remotely.
Yeah.
And can the parties, prosecution and defense, actually examine the witness during this commission?
Oh, absolutely crucial. Yes. They have options. They can submit written interrogatories, basically, a list of questions for the magistrate to ask the witness.
Okay.
Or, and this is important, they can appear themselves or send their advocate to conduct a live examination, cross-examination, and re-examination of the witness during the commission proceedings.
Upholding that vital right to cross-examine.
Absolutely essential for a fair hearing.
So once the commission is done, the testimony is recorded. What happens then?
The commission documents and the recorded deposition are sent back to the original court that issued the request. They're then made available for inspection by all parties.
So everyone can see what was said.
Yes, transparency. And that recorded testimony is then admissible as evidence in the trial, subject to all just exceptions, meaning it can still be challenged on relevance, hearsay grounds, etc. It can even potentially be used in later related proceedings if certain conditions are met.
And the trial court can pause things while this commission is happening?
Yes. The court can adjourn the main proceedings for a reasonable time to allow the commission to be executed and the evidence to be returned. Just a practical measure.
And finally, these rules also work in reverse. If a foreign court sends a commission to India.
Yes. The BNSS procedures for executing commissions, allowing party examination, and returning the evidence apply equally to requests received from specified Indian courts outside BNSS territory or from foreign courts where India has reciprocal agreements. It facilitates that mutual legal assistance.
Okay, let's revisit that UK example. Crucial witness for fraud case has moved to London. The Indian court issues a commission, sent through official channels. A UK court officer summons the witness. The Indian prosecution and defense lawyers can either fly to London to cross-examine the witness live during the commission, or they can submit written questions. The evidence is recorded meticulously under UK procedures, but adhering to the commission's requirements.
Okay.
That deposition, recorded in the UK, is sent back to the Indian trial court. Both sides get to inspect it. It's then formally read into evidence, but the defense can still raise objections. That part is irrelevant. That's hearsay.
Makes sense.
And conversely, if a UK court needs to examine a witness residing in Mumbai, they send a commission to India. The Mumbai CJM would then oversee its execution, following these BNSS rules, ensuring the request is handled properly.
Exactly. So what's the big picture for you? Justice is increasingly global. Whether a key witness is in Pune or Paris, the system has mechanisms to get their testimony. Trials aren't easily stopped by geography anymore. But critically, rigorous safeguards for examination and cross-examination remain firmly in place.
It's about adapting to a connected world.
It is, and it reflects the growing importance of international cooperation in legal matters, which always brings up that question of balance. How do countries manage national sovereignty while facilitating this essential cross-border legal assistance, ensuring foreign requests are handled effectively but also compatibly with domestic laws?
Right. Now, experts. We see them in so many modern cases: doctors, forensic scientists, financial analysts. Do they all really have to troop down to court every single time they write a report, even for something routine?
Yeah.
Seems like a huge drain on their time.
You've hit on a major pain point in the traditional system, absolutely. And the new code, the BNSS, takes a notably pragmatic approach here.
How so?
Its main goal is to save valuable expert time, which is often highly specialized and in demand, while still making sure there's proper judicial scrutiny. It draws a really crucial distinction between routine, often undisputed expert reports, and those findings that are genuinely contested and require the expert's personal presence for cross-examination.
Okay, so for medical witnesses like a civil surgeon who did an examination or post-mortem, their deposition can be used without them having to come to court.
Generally, yes. If their deposition was properly taken and attested by a magistrate with the accused present or recorded via a commission, it's admissible as evidence on its own. Saves the doctor a trip to court for potentially routine testimony.
Okay.
But, and this is the crucial safeguard, the court may still choose to summon them, and critically, it shall summon them if either the prosecution or the accused makes an application requesting their presence for cross-examination. The right to challenge is preserved.
Okay, so admissibility first, but summoning is mandatory if requested. What about identification reports by executive magistrates, like from a test identification parade, TIP?
Similar principle, the executive magistrate's tip report identifying a person or property is admissible as evidence. This streamlines getting the report formally into the case.
But there are caveats.
Yes, important ones related to the new evidence code, the BSA. If the tip report happens to contain statements that would otherwise be inadmissible under certain BSA sections, things that might hint at a confession made during the process, those specific statements don't become admissible just because they're in the tip report.
Ah, prevents backdoor admissibility.
Exactly. And again, the court may summon the magistrate and shall summon them if either party applies.
Okay. Now, what about reports from places like the Mint, government printing presses, forensic science labs, FSLs, or experts on questioned documents?
For specific gazetted officers in these highly specialized government bodies, their reports are also admissible as evidence directly. The court may summon the officer if it feels necessary.
But there are restrictions on summoning them.
Yes, two key ones. First, no officer can be summoned merely to produce the base records or raw data underlying their report. The focus is on their conclusions.
Okay, no fishing expeditions for internal data.
Right. And second, they generally cannot be compelled to give evidence based on unpublished official records or disclose the specific details of their testing methods without permission from their higher-ups, like the general manager or officer in charge. This respects official secrecy and expertise while still allowing their conclusions into evidence.
Got it. And then there's a broader category of listed government scientific experts: chemical examiners, explosives experts, fingerprint bureau directors, serologists.
Yes, a whole list of them. For these experts, too, their official reports are admissible as direct evidence. The court again may summon them if needed.
But here they can send someone else.
Yes, this is a very practical provision. If summoned, the expert may depute a responsible officer from their department who is familiar with the case to attend court and testify on their behalf, unless the court has specifically ordered the expert themselves to appear personally.
That offers a lot of flexibility, especially for busy senior experts.
It does. It covers much common forensic evidence.
Let's run through examples. Doctor's post-mortem report, properly recorded by a magistrate, can be tendered in court. Doctor doesn't need to come initially.
Correct.
But if the defense lawyer says, "We strongly dispute the time of death finding in this report," they can apply, and the court must summon the doctor for cross-examination on that point.
Exactly. The challenge triggers the summons.
Okay. Executive Magistrate's TIPI report says witness identified, accused, report admitted. But if the defense argues the parade procedure itself was flawed,
They can apply to summon the executive magistrate to question them about how the parade was conducted.
right. Mint officer's report says currency is counterfeit, report admitted. Defense lawyer cannot just demand the officer bring all the internal Mint manuals on counterfeit detection to court.
Not without specific permission, generally no. The focus is the report's finding.
And a chemical examiner's report finds poison in a sample. Report submitted. Examiner is tied up in another major trial. They could potentially send a qualified junior scientist from their lab who assisted with the analysis to depose in court instead.
Unless the court specifically demanded the examiner's personal presence, yes.
So what's the big picture for you? These rules mean potentially much quicker trials because many expert reports can come in as direct evidence, saves countless hours. But critically, you always retain that fundamental right to challenge the evidence by demanding the expert show up for cross-examination. Fairness is preserved.
It's about streamlining the routine to focus on the contested. It reflects the goal of expediting trials while keeping that crucial right to cross-examine intact. Which makes you wonder, how does this balance play out in practice? Does it truly achieve both efficiency and robust scrutiny, especially when dealing with complex, cutting-edge scientific evidence?
Right. Now, this next section, Section 330, this sounds like it could be a real game changer for speeding things up. This idea of no formal proof for undisputed documents and reports. What does that actually mean in practice?
You're absolutely right to flag this one. It is potentially a profound shift. It's aimed squarely at focusing precious judicial time only on the issues that are genuinely in dispute. It's a powerful tool designed to streamline trials and cut out a lot of unnecessary procedural delay.
Okay, so it sets up a mandatory admission or denial process. Parties have to say whether they accept the genuineness of documents and reports.
Yes, mandatory. Parties must include particulars of every document they rely on in a list. Then, soon after these lists and documents are supplied, the prosecution and the accused, or their advocates, shall be called upon to admit or deny the genuineness of each document.
Is there a deadline?
Yes, the code says no later than 30 days after supply, though the court can extend this time if there are good reasons stated in writing.
Okay, admit or deny within 30 days.
Yeah.
And then comes the really striking part about experts.
This is the kicker. A specific proviso states, no expert shall be called to appear unless the report is disputed by any party.
Wow. So if nobody objects to the expert's report, the expert doesn't have to come to court at all.
That's the implication. It completely shifts the onus. Instead of the prosecution having to formally prove every single document and call every expert, even if the defense doesn't really contest it, the burden shifts to the party who disputes it. If you don't dispute the expert report, the expert likely won't be summoned. It's a massive potential time saver for these busy professionals.
And what about the documents themselves? If their genuineness isn't disputed?
Then the code says the document may be read in evidence without proof of signature.
Meaning you don't need to call the person who signed it just to say, yes, that's my signature.
Exactly. It avoids that often perfunctory exercise for uncontested documents. Now, the court still retains the discretion to require proof of signature if it has specific concerns, but the default becomes admissibility without formal proof if undisputed.
Let's walk through an example. Prosecution files the police FIR, a seizure memo from the crime scene, and a ballistics report from an expert. The defense reviews them. They decide to admit the genuineness of the FIR and the seizure memo. And crucially, they do not dispute the findings in the ballistics report.
Right. What happens then?
Under this section, the FIR and the seizure memo can be read directly into evidence. No need to call the police officer who registered the FIR or the one who prepared the memo just to confirm their signatures.
Streamlined.
And because the ballistics report wasn't disputed, the ballistics expert does not need to be summoned to court to testify about their findings. That report can also be taken as evidence directly.
Huge efficiency gain. The trial can then immediately focus on whatever is contested, maybe the interpretation of those facts or other evidence entirely.
So what does this mean for you? Potentially drastically faster trials. If you don't actually challenge the authenticity of a document or the conclusions in an expert report, the court won't waste time on the formality of proving them. It's a very pragmatic approach, valuing efficiency and focusing on the real points of disagreement.
This significantly expands on older principles about admitting documents. Adding the expert report dimension is key. It raises a crucial question, though. While incredibly efficient, how do we ensure that all parties, especially those perhaps without seasoned legal counsel, fully grasp the significant consequences of admitting a document, or, maybe more subtly, not disputing an expert report? Are they always making a fully informed decision?
Ensuring understanding is key. Okay, what about things that seem like pure formalities? Does the court really need a live witness for absolutely every single procedural step?
No, thankfully not. And that's the practical beauty of these next few provisions. If we connect this to the bigger picture, it's all about discerning where direct oral testimony under oath and cross-examination is absolutely essential versus where a sworn written statement and affidavit can suffice. Especially for non-controversial or purely procedural matters, it saves enormous court time.
Okay, so one section allows facts about a public servant, if they're alleged in an application, to be given by affidavit at the court's discretion.
Yes. If you make an application to the court that includes allegations regarding a public servant's conduct, you, the applicant, may give evidence of those specific facts via an affidavit, and the court may, if it thinks it's appropriate, order the evidence to be given that way.
So it expedites consideration of those kinds of applications without needing full oral testimony right away.
Exactly. It helps with interlocutory matters. Then there's another provision for evidence that is of a purely formal character.
Formal character? Like what?
Think routine, undisputed procedural steps. Maybe confirming that a particular notice was dispatched on a certain date or that a specific form was filed. Things not usually central to the dispute itself.
Okay. And that can be done by affidavit too.
Yes. Evidence of a purely formal character may be given by affidavit, and that affidavit may then be read into evidence, again, subject to all just exceptions.
But like with the experts, there's a right to challenge.
Absolutely. The court may choose to summon the person who swore the affidavit, but critically, it shall summon them for cross-examination if either the prosecution or the accused applies. So it saves time for the routine stuff, but preserves the right to cross-examine if someone actually disputes the formal nature or the content of that evidence.
And the code is also specific about who can witness these affidavits being sworn and what needs to be in them.
Yes, crucial for reliability. Affidavits must be sworn before authorized people, a judge, judicial or executive magistrate, a commissioner of oaths, or a notary public.
Okay.
And the content rules are strict. Affidavits must be confined to facts within the deponent's personal knowledge. If a statement is based on belief, the affidavit must clearly state the grounds for that belief. You can't just say, I believe X. You have to say, I believe X because Y told me and Y was there.
Ground for belief. Got it. And the court can strike out irrelevant stuff.
Yes. The court has the power to strike out any scandalous or irrelevant material from an affidavit. It ensures they stay focused and appropriate.
Okay, let's illustrate. An accused person files an application alleging some misconduct by the investigating officer. Instead of immediately having to testify orally about it, the accused, as the applicant, could potentially submit an affidavit detailing those allegations, if the court allows.
Right. Streamlines that initial stage.
Or a court clerk whose only role was to formally deliver a non-contentious document to another office. They could submit a simple affidavit confirming the date and time of delivery, avoiding a court appearance for that purely administrative task.
Makes sense.
But if the fact of the delivery itself becomes disputed, we never received it, then that clerk can be summoned to testify and be cross-examined.
Exactly. And their affidavit would need to be clear. I personally delivered the document. Personal knowledge. Or maybe, I believe it was delivered because the dispatch register shows. Belief with grounds.
So what does this mean for you? For straightforward or preliminary issues, you might be able to use an affidavit, saving time and hassle. But the rules for these affidavits are strict. They need to be properly sworn based on knowledge or stated belief, ensuring they're credible legal statements.
This approach aligns with past practices, allowing affidavits in certain contexts, but it always raises that practical question for courts. How do you effectively draw the line? What truly constitutes formal character evidence suitable for an affidavit versus evidence that, even if seemingly simple, really requires the full scrutiny of live oral cross-examination?
That judgment call seems key. Okay, let's wrap up with these final, quite specific but interesting sections. What happens if someone has a previous conviction? How does the prosecution prove that formally? And what if an accused person just disappears, absconds? Or a crucial officer who wrote a report retires or gets transferred? Does the system just get stuck?
Not necessarily. These final provisions really show the BNSS trying to be resilient, trying to adapt to these real-world practical challenges. They ensure justice can keep moving even with absent individuals or changing personnel while still maintaining fairness.
Okay, so first, proving a previous conviction or acquittal. There are specific methods.
Yes, streamlined methods. You can use a certified extract of the sentence or order directly from the court's records.
Oh?
Or specifically for proving a conviction, you can use a certificate from the officer in charge of the jail where the person served time or the official warrant of commitment that sent them there.
But just the document isn't enough.
Correct. A crucial requirement in all cases is evidence linking the identity of the accused person currently in court with the person named in that previous conviction or acquittal document. You have to prove it's the same person.
Identity proof is key. Makes sense. Streamlines proving past outcomes, which is important for things like enhanced sentencing.
Exactly. Now, what about absconders?
Yeah, what if the accused just vanishes?
This is another exception to the rule about the accused needing to be present. If an accused person has absconded, and there's no immediate prospect of arresting them, the court is empowered to go ahead and examine the prosecution witnesses anyway and record their depositions in the accused's absence.
To preserve the evidence.
Precisely. Because witnesses might move, forget details, or even pass away over time. This recorded evidence can then be used against the accused if they are eventually arrested, but only if the original witness, the deponent, is now dead, incapable of testifying, cannot be found, or getting them back to court would cause unreasonable delay or expense.
Okay, strict conditions for using it later.
Yes, and there's a similar provision for grave offenses, punishable by death or life imprisonment committed by unknown persons. A high court or sessions judge can direct a magistrate to inquire and examine witnesses even before anyone is accused. Those depositions can then be used against someone later accused, again, if the original witness is unavailable. It's all about preventing evidence from being lost forever.
A vital tool, especially for complex or cold cases. Okay, now the big one, officer transfers and retirements. What if the police officer who wrote the seizure memo, or the forensic expert who wrote the DNA report, is no longer available?
This is a major reform aimed directly at tackling delays caused by this very common issue. The BNSS has a pragmatic solution.
What is it?
If a document or report prepared by a public servant, expert, or medical officer is needed as evidence, but the original officer who made it is unavailable, may be transferred, retired, deceased, can't be found, medically incapable, or even just bringing them back would cause significant delay.
Okay, lots of reasons for unavailability.
Then the court shall secure the presence of the successor officer, the person currently holding that post, or responsible for those records to depose on the document or report.
The successor steps in.
Yes, the successor provides continuity, verifying the document's official nature or explaining the standard procedures under which it would have been generated.
But wait, did we just discuss undisputed reports?
Exactly, and that crucial proviso applies here too. No official, not even the successor, shall be called unless the report is disputed by any party.
Ah, so if the report itself isn't challenged, you don't even need the successor to come.
Correct. That significantly streamlines things further. And another modern touch, the deposition of the successor officer, if needed, may be allowed through audio-video electronic means.
Efficiency upon efficiency.
It's a major attempt to deal with a chronic source of delays, leveraging undisputed evidence and technology.
Okay, let's see this play out. To prove accused P's prior conviction, prosecution brings the certified court order and maybe a fingerprint expert to testify that P's prints match the prints on file for the person convicted in that order, proving identity.
Right. Connects the person to the paper.
Accused R absconds mid-trial for a serious charge. The court records testimony from key witnesses now, preserving their account. Years later, R is caught. One witness has sadly died, That previously recorded deposition can now be admitted as evidence against R.
Preserving justice despite the absconding.
In the successor officer example, the police inspector who meticulously prepared a crucial crime scene sketch and seizure memo retired last year. The current inspector in charge of that station can now be called to court to depose on the memo, verifying it as an official document from their records.
Providing that link.
But even more significantly, if a forensic lab submits a DNA report and neither the prosecution nor the defense disputes its findings,
Then the DNA expert doesn't even need to be called to court, not the original one, not their successor. The report comes in undisputed, tremendous time save.
Right. So what's the final takeaway here? The justice system is built with mechanisms to navigate tough challenges, proving past records, dealing with people who flee, handling staff turnover, and critically, this powerful new efficiency tool means if everyone agrees on an expert's report, that expert's valuable time isn't wasted in court, speeding things up considerably.
It builds on older principles, but the successor provision and the explicit link to non-disputed reports are key expansions. Which does lead to a final practical thought. How will this successor officer provision work smoothly? How can a successor genuinely speak to a report made by their predecessor, maybe involving complex analysis they didn't personally conduct, while still providing meaningful testimony? Ensuring they can verify the record without overstating their knowledge seems crucial.
Outro.
So, after covering all that ground, what's our ultimate takeaway from this deep dive today? We've really journeyed through some of the most, dynamic and practical parts of the new BNSS, haven't we?
We certainly have.
From the fast-track world of summary trials and the strategic option of plea bargaining to the very careful rules for bringing prisoners to court and these modern, sometimes quite streamlined ways of handling evidence. It really feels like the overall goal is a more efficient, but still fundamentally fair justice system.
Exactly. We saw how even speedy summary trials have those strict sentence caps as a safeguard. We saw how plea bargaining, while offering a shortcut, is fenced in by rules about voluntariness and making sure victims are considered, specifically with compensation.
Right.
And how, even with all the logistical headaches of dealing with people already in prison or getting expert testimony efficiently, the system lays out clear rules, even embracing technology to keep justice moving.
Yeah.
Always with that eye on fairness and transparency.
Indeed. And looking at all these provisions together, you really see that fundamental tension, don't you?
You really do.
The constant push for expediency, trying to manage an overloaded system balanced against those absolute non-negotiable requirements of due process, fairness to the accused, fairness to victims.
And the DNSS really tries to navigate this tension by providing these specific, detailed procedures, including some potentially big changes, like largely skipping formal proof for undisputed documents or allowing successor officers to testify. It's a fascinating evolution, clearly trying to find efficiencies wherever possible, while hopefully rigorously maintaining those essential judicial safeguards.
Which brings us to a final, maybe provocative thought for you, our listener. As legal systems everywhere keep modernizing, keep searching for greater efficiency, where do you personally draw the line? How much streamlining is good? And at what point does it risk compromising that deeply human element of justice, where individual stories, nuances, and contexts sometimes just don't fit neatly into standardized boxes?
A crucial question to ponder.
Well, thank you for joining us on this deep dive into the Bhartiya Nagrik Suraksha Sanhita 2023. We genuinely hope you feel a little more informed, perhaps a bit more engaged, and definitely a lot more curious about this intricate, ongoing dance between law and justice.